Bienvenidos a la sesión de la tarde de nuestra conferencia sobre compliance, anticorrupción e investigaciones. En esta oportunidad, como primer panel, vamos a contar con el Departamento de Justicia de Estados Unidos para analizar algunas de las múltiples cuestiones que surgen en la práctica en estos temas. Vamos a tener ese panel en inglés, so we are switching into English now. So the first step is that I will introduce Lorinda Llegó. She's the FCPA Unit Principal Assistant Chief at the DOJ. So thank you, Lorinda, for joining us. And for the first question, we will bring to the table the Memorandum on Fighting Corruption issued by President Biden. This memorandum established the fight against corruption as a core U.S. national security interest issue. So we would very much appreciate hearing from you what this memorandum means in terms of actual enforcement of anti-corruption regulations, particularly considering cross-border cases. So thank you again for joining us. We truly appreciate it. And we will be happy to hear from you on this particular topic to begin with.
Thank you so much for having me. It is a privilege to be here talking with you guys today. I will start off saying what I have to say every single time, which is that I am speaking on my own behalf and not on behalf of the Department of Justice. Mm-hmm. So with that disclaimer out of the way, yeah, I mean, the memo outlines some of the consequences of corruption, including undermining the rule of law, eroding public trust, and other consequences. But the FCPA unit has been focused on fighting corruption for decades, and we remain committed to our mandate. And as prosecutors, it is our job to follow the evidence, and doing so has allowed us to bring very significant cases in Latin America in the last several years. We've been able to bring these cases in part due to the relationships that we have built and continue to build with our counterparts there. And we look forward to working with those partners, continuing to build those relationships, especially in the Northern Triangle region.
In previous panels, we were discussing with chief compliance officers and with people in the private sector how important it is to running those positions to be able to have significant teamwork. So from your words, I get that teamwork is also relevant to the DOJ when interacting with your counterparts in other countries when dealing with cross-border cases. So that being said, we would also appreciate to hear from you on this somewhat recent development regarding the expanded reach of subpoenas to foreign banks with U.S. correspondent accounts. There has been a lot said about this in Latin America, certain kind of concern. So what can you tell us about this in regard to how it will actually impact real life?
Yeah, and for that, I mean, what I will say is for every single investigation we have, we evaluate the tools in our toolkit and think through which tool we can use in that case to obtain the evidence that we're looking for, right? So, we look at everything we have, we look at what are we looking for and how do we get that information? How do we get that piece of evidence? Now, at the same time, we also understand the diplomatic sensitivities of compelling the production of overseas documents. But the NDAA subpoena is a tool that we have. It is one that we are going to consider, and that one that we will use in the appropriate circumstances. Thinking about the particular case, thinking about diplomatic sensitivities, all of that combined.
All right, so you made it quite clear so far in the few minutes we have been talking that evidence is the goal of an investigation by the DOJ, which may come naturally to you. Sometimes this is not the case for in-house executives. So this is quite important. What I see in practice also relates to evidence, particularly when we handle internal investigations. So on that note, I would appreciate to hear from you on what kind of cooperation the DOJ expects from companies conducting internal investigations in regard to some reports of potential corruption. I mean, this is a big issue for many companies because not only they have to deal with what goes on inside the company, but also with how to present it to authorities like the DOJ. What can you tell us about that? There are many general counsels and compliance officers on the other side who would love to hear about this.
Yeah, I mean, this is a very important point. I mean, we at the DOJ have tried to be transparent in what we expect from companies, as part of cooperation with us. So, one of the ways we've done that, and the main way we've done that, is through the corporate enforcement policy. And that policy provides guidance to companies who are looking to cooperate. It also provides, it explains the additional benefits to companies based on whether companies self-disclose the misconduct, fully cooperate, and timely and appropriately remediate. But the CEP makes our expectations clear, right? If a company chooses to undertake its own investigation and to cooperate with DOJ, then we are interested in hearing the results of that cooperation. As you said, for us, what is important is gathering the facts, gathering the evidence. So what does that mean? What does full cooperation mean? It includes, again, the CEP outlines some of this, right? So it includes, among other things, timely disclosure of all facts relevant to the wrongdoing, including all facts gathered by the company's independent internal investigation, if the company chooses to do one. Attribution of those facts to specific sources where such attribution does not violate the attorney-client privilege. So if a witness said something, if a fact comes from a specific document, attributing it to that so that we can actually look at the underlying evidence ourselves, that is important. That is important to us. What we're not looking for is sort of a general narrative of facts that does not say where those specific facts came from. And this cooperation has to be proactive, right? So that means that we expect companies to give us relevant information, even if we don't know to ask that question, even if we don't know to ask that information, right? Because the company, they're the ones, in this case, they may be doing the internal investigation. There might be something they learned. There might be a relevant piece of evidence they've learned about that we don't even know exists, so we don't know to ask for it. What is important to us? Cooperation isn't just responding to our requests, right? Cooperation is being proactive, telling us what the company is finding. And I think another important point is giving us information about how we can gather other evidence not in the company's possession, right? So the company may know about a bank account that doesn't belong to the company, but thinks it may have relevant information. It may know about a personal email account that someone was using. Right? Those are the kinds of things, we obviously have tools beyond what companies have. So giving us that information, pointing us in the right direction of, here are the documents we can present to you, but here's some other places you can look for additional information. That is important. That is part of being proactive in the cooperation. Another really important area is electronic evidence. What is the company doing to timely preserve, collect, and disclose electronic evidence? So one of the most important part is the preservation. Companies, how's the company thinking about document preservation? Not just when it realizes it has a problem, right? But before that, just as a general practice, how is it ensuring that communications, electronic evidence, electronic materials are preserved so that, the company itself can find out what happened, and if they're interested in cooperating with us, provide us with that evidence. And so, specifically there, we're thinking about ephemeral messaging applications, right? A lot of, in some parts of the world, that is how people communicate. In some parts of the world, people are not really using email or SMS text as much. They're using WhatsApp, they're using, other ephemeral messaging applications. And so in that context, if a company has, employees, agents, who are using these ephemeral messaging applications, how is the company thinking through preserving that? How is a company thinking through making sure that if there is, eventually, if someday there's evidence of potential wrongdoing on those applications, they have access to it, so they can look at it themselves, right? And from my perspective, so they can share it with us. Another thing we're thinking about is in terms of, disclosure of electronic evidence, disclosure of overseas documents, right? So, sometimes companies have issues with blocking statutes, data privacy, or other, laws in foreign jurisdictions that they claim or they explain prevent them from providing overseas documents. So, the CEP makes it clear again that the burden is on the company to explain the prohibition, right? The burden is on the company to say, here's the law, here's how we interpret it, here's why we interpret it this way, and here's what we think it prevents us from being able to give you, right? So the burden is first on the company to provide us with an explanation on the prohibition. And then the second part of that is the burden is also on the company and we're willing to work with companies to think through and to work diligently to determine whether there is a legal way to get us that information, to get us those documents. And the reason I say that is sometimes, when we press companies and press them, we find out that although the information may be in a jurisdiction with a blocking statute, right, there are backup servers somewhere else that doesn't have a blocking statute. Sometimes we find out there are backup servers actually in the United States, which makes that easier for them to produce those documents to us. So, in those kinds of situations, it is important to both explain what the prohibition is and to tell us, we have thought through all these different ways to try to get you those materials. And either we've come up with a proposed solution or, here's why we don't think we can do it, right? So I think that's really important. And so obviously feel free to interrupt me at any point in time, but I think another point that is important for cooperation is privilege, right? We always engage with companies and discuss how companies can get us the information we need without implicating privilege concerns, right? And that conversation and that outcome is based on the unique facts and circumstances of each case, right? Or the specific information sought. So again, the FCPA by definition involves conduct that occurs overseas, evidence that occurs overseas, right? Where we are enforcing a statute that criminalizes the payment of bribes to foreign officials. So oftentimes we have issues with cross-border privilege, right? So, what happens if a document or information is not privileged in the foreign country where it resides, right? Then in that situation, what we're doing is having a conversation with the company, engaging in a case-by-case analysis as to whether the information is privileged here, right? So it is not necessarily a given that if it's not privileged in another country, it's not privileged here. We have to do sort of a choice of law. We have to do an analysis in that specific instance. And, one of the things we look at, obviously for privilege concerns in the United States, what is important is the expectation of confidentiality. So is there an expectation of confidentiality when those documents or that information was created or preserved or stored? So, it is a case-by-case, working through privilege issues, working through cross-border privilege issues. And, I think one thing that's important is, if a document is in fact privileged in the United States, the Department of Justice cannot and will not ask for a privilege waiver. That is our policy. But we've also found that, if a document, if a company chooses, because as you said, a lot of times we're working in parallel with foreign authorities. And so a lot of times if a company chooses to give documents that may be privileged or would otherwise be privileged in the United States, if they choose to give those documents to a foreign authority, oftentimes my experience is they will also give it to us, right? So because if we are doing parallel resolutions, if there are companies interested in a global coordinated resolution, they often want everyone to be singing from the same song sheet, right? To everyone to have the same foundation or foundational understanding of the facts. So, so look, this is a long way of saying the incentives for the companies, the incentives are clear. The incentives to cooperate, are clear. We've tried to be transparent about that. There is, the CP outlines this, but there's a presumption of declination for companies who voluntarily self-disclose, cooperate, and remediate. There are some caveats that are in the CP, but that is the presumption. That's where we're starting from. And for companies who don't voluntarily self-disclose, there is still, a chance to get maximum cooperation credit, a reduction from off the guidelines for companies who do fully cooperate, even if they're not, if they did not self-disclose. So, the incentives are there, and I think we've tried to be clear about what we expect.
Well, thank you very much. That's a lot of information. That was a quite clear description of the highlights. Certainly very useful for those of us practicing abroad. And right at the beginning, you mentioned timely disclosure. So my question to you is, if you can expand a bit more on that. For example, the scenario in which a company is receiving a report on alleged corruption, evaluate the situation, and decides to start an internal investigation. Is that the appropriate time to reach out to the DOJ? Should the company move forward and then approach the DOJ as soon as a reasonable suspicion of corruption actually arises in the investigation? Should the company reach to the DOJ right at the end, after all the work has been done? What can you tell us about that?
Yeah, so I think that's really a choice the company has to make, right? But what I will say about that is for the CEP declination, the CEP policy, the possibility of a declination of disgorgement, it is an on-off switch, right? So you have to voluntarily self-disclose for you to even get into that category. If you do not, you're just out, right? It is an on and off switch. And so when it comes to timeliness, the CEP explains that one of the things we look at is whether the disclosure was whether the company came in before there was an imminent threat of disclosure or government investigation, right? So when a company is thinking through when to disclose to DOJ, they're just running a risk, right? It is, again, the company's choice, but they're running a risk. If they come in right away, they are probably more likely to get voluntary self-disclosure credit. If they wait, maybe they do a little bit of an investigation, very short period, come in, maybe they do, like you said, the option would be do the full investigation and then come in. Look, the company is running a risk. There are whistleblowers. Whistleblowers are coming in all the time. Press reports, the press they're breaking stories all the time. Other governments, again, this is a global fight, and other governments are bringing cases, are charging individuals, and so there is a possibility another government will bring an investigation. And so, what you do not want is to be in a situation where you had the information, you chose not to disclose at the time. A whistleblower comes in, we reach out to you, or you reach out to us and we say, thank you very much. We've been looking at the same thing for 3 months because a whistleblower came to us, right? Or, another government enforcement authority also is looking into, but basically you don't want to be in a position where you come to us and we already know, or you come to us and we're now engaged in a discussion about whether or not your disclosure meets the standard for voluntary self-disclosure. Right? So it's just a sort of risk reward each company decision companies have to make for themselves.
Quite clear. Actually, all throughout an internal investigation, companies are making strategic decisions, right? And there is risk and reward to be balanced all the time. So now that you bring to the conversation the possibility of other countries, other governments being involved in a case, in these scenarios, which are cross-border, in which a company is exposed to more than one law in more than one country, assuming one of those laws and those countries are the FCPA and the US. So what is the expectation of the DOJ in regard to this company reporting the case, who should they reach first to? Let's suppose it's a company operating with headquarters in country A, no matter which country, and the US is also relevant because they are exposed under the FCPA, and there are two other countries involved. Does it really matter who this company reaches out first to? Should it be the DOJ? What are the expectations in this regard?
Yeah, and so again, I can't obviously speak for any other law enforcement authorities. I can only speak from my personal experience, and again, not on behalf of DOJ. But what I will say in that situation is, companies again have to think through the CP on and off switch, right? Like if they want to get credit for voluntary self-disclosure, how do they best position themselves to get that? How do they best position themselves to one day not be in a conversation with us about whether or not we're going to consider their disclosure to be a voluntary self-disclosure? Look, and companies have done it lots of different ways. Companies, like you said, who have exposure in multiple jurisdictions often have attorneys in multiple jurisdictions who are making calls closely simultaneously, right? So they have US counsel, they have Brazilian counsel, they have UK counsel, they have, I'm just naming countries, French counsel, Swiss counsel, right? And so they're trying to coordinate, letting everyone know around the same time, because they don't want to ruffle any feathers. Like you said, maybe they're a French company or a Swiss company, a Brazilian company, a UK company, but they also want to make sure they get in with us so that they're clearly a voluntary self-disclosure, right? There are lots of issues and factors they're considering at the same time. So, companies have found ways to sort of try to do something more simultaneous, because as you said, there is increased cooperation among law enforcement authorities. And that is going to continue. I have no reason to believe that is going to slow down. And so companies just take the risk if they go to just one authority and disclose it, that we find out before they come to us, right? So it's just a matter of trying to coordinate that.
Yeah, actually, that is going to be my next question. We have seen in recent years that cooperation among authorities from different countries has increased. It has not only increased in number, but it has also become more efficient, right? It's usually no longer the case that it takes a written document to travel from one part of the world to another and take, 5 months and 50 government authorities involved to actually get an answer from someone on the other government involved in the case. What can you tell us about what to expect for the future in regard to cooperation among multiple authorities pursuing corruption-related cases?
Yeah, and so I think, I've said this a couple of times, but the fight against corruption really is global, right? So we have the statutes we enforce, the jurisdiction we have, and we are working very diligently on that. Other enforcement authorities are doing the same thing. Almost by definition, as I said, FCPA cases involve conduct abroad, right? Which means evidence is abroad. Witnesses are abroad, documents are abroad, and we have to find a way to get that. Vice versa, a lot of times there's evidence in the United States that a foreign authority may want access to, witnesses who are here. And so, as you said, in the sort of olden days, it was getting information from another country was treaty-based. It was formal. It was slow. Not the case now. We are, like I think you mentioned, and I said, we are increasingly working alongside, in parallel with our foreign authorities. And it's been a huge help in our investigations, right? It has meant, we're able to seamlessly share evidence and information. We're supposed to share evidence. We're able to share evidence when appropriate, informally, instead of going through a formal MLAT, or informally first and then maybe follow up with a formal request. We're able to get leads from other countries. Like I said, if another country is investigating a case that touches on the United States, we may get a heads up from them that, hey, we're looking at this. Are you guys interested? And once that happens, we again will share information about what we are developing in our own sort of separate but parallel cases. And the international cooperation also means countries don't get to play one authority off, companies don't get to play one authority off the other. We are talking with each other, And if a company is saying one thing to one authority and a different thing to another authority, it will come out. And so the cooperation has really, and you can see the results. Right? I think you can see in the last several years the very, the coordinated large corporate investigations that have involved, many um, authorities coming together, negotiating, like I said, separate parallel cases, but coordinated at the same time. You have the anti-piling on policy, right? That gives incentives to companies to try to resolve their exposure, globally instead of doing it piecemeal. And I think that is helping us, further this fight against corruption and achieve, each of our individual mandates. And I will say this too. I mean, COVID has been a difficult time for everyone, right? We've all in the last 18 plus months, I guess, try to figure out a way forward, right? But we are still here. We're still working. We're still talking to people. I mean, COVID means we're not traveling and meeting in person as much, right? But we're still in close communication, just like law firms have found a way to talk to their clients via Zoom or talk to each other via Zoom. We are finding ways to continue to remain in close contact with our law enforcement partners. And I expect this to continue.
Yeah, you raised a very good point. It's true. I mean, among law firms involved in these kind of cases, we are in touch, we learn from each other, we exchange information. I mean, we discuss strategies. And that's what we see that law enforcement is starting to do all over the world, also working somehow in teams. And we see that trend increasing. We don't expect that to change in the future. So that being said, it's also true that some people, particularly regarding certain cases, have complained that multiple authorities involved in the same case could mean overlapping authorities, overlapping of penalties. So what can you tell us about that?
So, we have the anti-piling on policy that, we really think through here, right? And so, again, the anti-piling on policy is there to ensure that companies, exactly to avoid what you described, companies don't get double penalized, triple penalized for the exact same conduct, right? So if multiple jurisdictions are looking at that conduct, we in the United States and the other authorities have been also doing this, thinking through what is there could be a global penalty. And sometimes it doesn't always match up, right? Sometimes the US has jurisdiction over more conduct or slightly different conduct than another jurisdiction. But on the overlapping conduct, what is the appropriate penalty and how is that, how should those penalties be credited among the different law enforcement authorities who are working on a case? And so, we are very attuned to that issue about making sure that companies are not, paying more penalties, twice as much, 3 times as much than they would otherwise if just one authority was involved. So I think, one thing that is important to note, though, right, is the anti-piling on policy does require some level of coordination by the company, right? So you cannot have a situation where the company sort of chooses some authority and says, I'm just going to go forward, resolve with them, and then go tell the United States later, you don't have to worry about this conduct. I already did this resolution on the side. And then if we do decide to do a resolution, say, well, you should credit that. It won't work that way, right? So companies should be thinking holistically if they're expecting crediting.
All right, so by now we have talked about companies, we have talked about authorities and governments. For the final part of the panel, we still have 7 minutes to go. I would like to talk about individuals. Many times we see company executives, people making decisions, assuming that these kind of cases mean a certain penalty, fine for a legal entity. It could be larger or smaller, but the fine will be paid, the legal entity will continue to do business in the future, and that's it. So it's important, I think, to address the fact of individuals being also involved in this case. So how are usually individuals impacted by these investigations? What is the kind of exposure they have to regulations like the FCPA, for example? And what happens when things go wrong for individuals?
Yeah, so I mean, the FCPA, we have jurisdiction over legal entities, so legal persons, companies, and individuals. And I think of it as, companies and individuals are sort of two sides of a coin, because people commit crimes, and companies can be liable for those crimes. So it is, at DOJ, we try to deter corruption, try to deter this kind of criminal conduct by holding both the individuals and companies responsible, right? Having one without the other, you need to incentivize. People will stop doing this stuff if they're afraid of going to jail. Companies will try to ferret out and stop this conduct if they're afraid of, a resolution of us, right? Or want to avoid a resolution of us. And so, DOJ, especially the FCPA unit has, the number of individuals we charge has grown exponentially in the last, probably 5-6 years. We are very focused on holding individuals accountable for their criminal conduct. And again, this is a way where, again, two sides of the same coin, right? So companies can provide evidence as part of their cooperation that helps us determine, which individuals are involved, which individuals could be held liable. Alternatively, individuals can provide information that helps us determine whether the company, the corporation, should be held liable for their conduct. And so, it is really something that we believe, I believe goes in tandem, and, very much focused and will continue to be focused on prosecution of individuals.
So following up on those words, are there cooperation rules that will also help individuals who decide to disclose information to the DOJ, for example, in a corruption-related investigation? So in a way that a certain individual who is a member of a company, when involved in an investigation, decides to disclose information, and then suddenly his interests begin to collide with those of the company. You see, my point is, usually beforehand, the interests of individuals in the company tend to be aligned. But when investigations begin, when evidence starts to come to the surface, which, by the way, evidence is always about people, right? Somebody sent the email, somebody made the wire transfer, somebody was participating in that meeting or made that phone call. So it's a lot about individuals. And many times, as I said, we see that in the private sector, we tend to underestimate that situation. So my question is, how much those regulations providing incentives for individuals to cooperate impact these kind of cases in a way in which these individuals actually disclose information about what was going on at the company?
Yeah, so I mean, companies and individuals' interests may or may not be aligned, right? So you obviously have a situation where you said individuals commit misconduct, and oftentimes we see as part of the company's remediation, they separate from those individuals, right? They terminate their employment, or if it's a third-party agent, they terminate that agency relationship. In the same way, individuals who are involved in the conduct, may decide early on they want to cooperate with the company's, the department's investigation to, potentially implicate other people, maybe more senior people in the company that knew about and were involved in misconduct. Maybe they want to, provide information about potential deficiencies in the company's controls environment. So this is something that companies, from what I've seen, work through, all the time, right? And they make decisions about whether, if it's a current employee, should they have, individual separate counsel, how is that all going to work? And so, these are issues that companies routinely work through. But you're right. I mean, the interests are not always going to be aligned.
Lorinda, my final question for the panel, we still have 2 minutes to go. What can you tell us about remediation and how relevant it is when a company gets involved in these kind of cases? How much attention should be given to what to do afterwards? After eventually corruption was committed, what should companies do in regard to their compliance program, procedures, controls, in terms of remediation and how to handle that with the DOJ?
Yeah, remediation is critical, right? So, and that comes in many, many different forms, right? So some of it is what I talked about, individuals. It has a company identified culpable individuals in the entity, and what has been their response? And there are different levels of culpability. There are times when a company will separate from the individual to terminate their employment, and there are other times where maybe someone is lower level, was very minimally involved in the misconduct such that they get additional training, right? So we are looking at, what is the companies doing to ensure that culpable people are held accountable. We're also looking, though, at what the company is doing to ensure that it creates an environment such that this doesn't happen again. And that's when we get to controls, compliance programs. And again, we're trying to be transparent, and we have provided additional guidance on how we evaluate compliance programs. And one thing that's important is, we will look at both the compliance program at the time of the misconduct, understand the root cause analysis, what happened, what went wrong. But we also look at the compliance program at the time of the resolution. What has the company done? Where is the company's program now? And most importantly, is it tested? Has the company tested that program to make sure that it is properly implemented and functioning properly, right? So you can put in a lot of controls, but have you actually made sure it's working? So, there isn't a big incentive for the company. Oftentimes, our investigations take a little bit of time. And so the company has an opportunity to improve its compliance program, its controls in that interim. And so what we're really looking at is what has it done and has it been tested?
Quite clear. What I have heard shows that at least a few words are kind of the highlights of our conversation. So you said timely disclosure at the beginning. You talked a lot about evidence, and you are clearly stating how relevant remediation is. On that note, we have reached the end of our panel. Lorinda, thank you very much for taking the time of having this conversation with us. I'm sure it has been instrumental for a number of people listening to our conversation on the other side. So thank you very much. We are coming back. Thank you very much.
Thank you for having me.
Thank you. We are coming back in 1 minute with the next panel. Thanks. Muy bien, estamos de regreso para nuestro siguiente panel en el que vamos a hablar sobre lo que la SEC y el DOJ esperan de las empresas en relación con sus programas de compliance y en lo que hacen cuando se disparan investigaciones. En este caso contamos con dos expertos del sector privado y vamos a hacer nuevamente este panel en English. So we are switching into English now. Let me introduce Mark Berger. He's a partner at Simpson Thatcher, and he's a former SEC director, and he also had a past with the DOJ. We also have Albert Stiglitz, partner at Alston & Bird, and former acting principal deputy chief at the DOJ criminal fraud section. So thank you very much, Mark and BJ, for joining us today and for participating in this conference. The purpose for this panel will be discussing what the SEC and the DOJ, two authorities that you know quite well. You've spent there a number of years. And now that you are in the private sector, what should companies keep in mind when dealing with these two regulators? So my first question goes to you, Mark, and is what should be expected from the SEC and the DOJ in terms of corruption-related enforcement in the near and the mid-term future?
Sure. Well, thanks, Gustavo. Let me say thank you to you and Marval for inviting me to the conference first. I'm happy to be able to participate. I will say, as BJ knows quite well, there are far fewer approvals required to speak at a conference when you're in private practice and not in the government. I'm just happy to be here with you all today. So from the SEC side, look, a lot has been written and said about priorities at the SEC, how they'll shift, what we'll be focused on, how aggressive they'll be. You know, it's worth just taking a quick step back. You know, the SEC Enforcement Division is a large ship, 1,400 or so enforcement attorneys, accountants, investigators. And there are many investigations that have been in the pipeline for quite some time. The average lifespan of an investigation is well over a year. And when it comes to FCPA investigations and other anti-corruption investigations with international components, you know, those take several years. So look, there's going to remain a steady flow of FCPA investigations that have been in the pipeline for quite some time. Certainly a new chair of the SEC. We have a new chair, Gary Gensler, comes with an agenda. He's touched on many themes, cryptocurrency, fraud at, you know, large financial institutions, market structure issues, including what happened at GameStop. But, you know, frankly, there actually hasn't been too much said about the FCPA. Now, you know, I think if this administration wants to, and I'm talking about both the DOJ and the SEC, there is certainly room for continued expansion of terms under the FCPA. We saw 5 or 6 years ago a focus on job opportunities for sons and daughters of state-owned officials to be the thing of value that was offered for business opportunities. And I could see the types of non-cash things of value expanding with this administration. You know, at the SEC specifically, enforcement's going to remain strong. Prosecutions there are conducted by a specialized group of an enforcement team within the Division of Enforcement. The head of that unit, Charles Kane, a former colleague of mine. He's passionate about the work he does. He's a hard worker. He's very smart. And he's armed with attorneys across the country who are going to work these cases and are quite skilled at this work. I guess one last point I'll say before, you know, turning over to BJ or flipping back to you, you know, there is one area at the SEC that is continuing to draw attention, and that bears upon new FCPA investigations, and that is the SEC's very successful whistleblower program. You know, whistleblowers who come forward with, you know, high quality original information that leads to a recovery of over $1 million in sanctions, they can earn, as many know, up to 30% of the total amount recovered. And just by way of example, one whistleblower last week earned himself $110 million in recovery. So you obviously have a huge incentive to spark new investigations. And so I expect anti-corruption investigations to continue to thrive in the next few years.
Thank you for that, Mark. I remember years ago when whistleblowers were still something rare. the discussion was how will people come out and disclose information when they know that most likely they will not get a job in the future, because of doing so. How will they maintain themselves? Well, $110 million as a reward would certainly, make the trick. So you also mentioned a couple of words that keep popping up in different panels throughout the conference today, which are cryptocurrencies and, again, whistleblowers, right? So on that note, BJ, you have just left the DOJ to join private practice. What can you tell us about what to expect from the DOJ in terms of anti-corruption enforcement for the short and the midterm future?
Thanks, Gustavo. And let me just take a moment to, just as Mark did, say what a pleasure it is to be here at what really is a terrific event that you and your firm have put together over the past several years. I really I appreciate the opportunity. I also want to say what a pleasure and frankly what an honor it is to be here with Mark, who, as I hope everyone attending this event knows, is someone with really an incredible record of public service and who's been tremendously successful both in the public sector and the private sector. So someone with tremendous insight on these issues, and it's a privilege to be here with him. So thank you both. Thank you to everyone who's involved in making this event happen, and thank you to the audience for your attention. It's really, really great to be here. So with respect to your question, let me highlight, I guess, 3 points in terms of sort of what to expect from the DOJ in terms of corruption-related enforcement in the near term. I think the first thing I'd highlight is something that is no doubt familiar to this audience, and that's the emphasis that the administration, the Biden administration, has placed very explicitly on combating corruption in Latin America. And that's something that can be expected to continue to inform enforcement activity in the future. As you know, the Department of Justice has, of course, brought a significant number of very high impact cases in Latin America going back several years. So anti-corruption work in that part of the world is certainly not a new thing for the Department of Justice, but the fact that the current administration is so explicitly focusing on it, focusing on corruption in that part of the world should leave no doubt that again will be a significant focus going forward. The second point I'd highlight would be the ever-increasing scope of the DOJ's international cooperation in enforcement. And what I mean by that is, of course, the ever-expanding roster of international enforcement agencies with which the DOJ is partnering in its resolutions. This is something I have every expectation you'll continue to see in the future. And really, you can think of it sort of that expansion in 2 ways, sort of the who and the how many. And what I mean by who is that you certainly can expect the DOJ to continue to partner with new and different enforcement authorities across the globe. In other words, enforcement authorities with which you might not have seen the DOJ partner or coordinate resolutions in the past. And when I say how many, what I refer to is that, just like in, for example, the Goldman Sachs resolution last year, you can expect the DOJ to continue to partner with and really spearhead multi-agency global resolutions with large numbers of its foreign counterparts. And here again, Gustavo, this is of course not a new thing, as the Department of Justice has worked with its international partners for many years in its corruption-related investigations. But just I mention it here because I have, again, every expectation that trend is going to continue and, if anything, increase. I'll talk more in a minute, maybe, about what that degree of international cooperation and coordination means for companies and individuals that are facing enforcement scrutiny. But for now, I want to just flag that is certainly something that that folks can feel confident in expecting to see in the near term. Third and last point that I'll flag is with regard to the proactivity of DOJ prosecutors in the anti-corruption space. This is not a group of people that is waiting around for cases. To the extent there ever was an era where the DOJ could credibly have been accused of waiting on companies to walk in cases. That era is long gone. Instead, what companies are facing is a DOJ that has significant experience and expertise in complex cross-border corruption cases. They've got that under their belts, and they're aggressively looking to identify corrupt conduct through a variety of means that don't rely on a company walking it in the door. So what that means, of course, for companies is that now more than ever, you not only need to ensure that your anti-corruption compliance program, your internal controls are as robust as possible, but that when something surfaces, right, when suspected misconduct surfaces, you're in a position to quickly make a well-founded and smart decision as to what you're going to do and how, if at all, you're going to engage with the Department of Justice. You and Mark have both mentioned whistleblowers, and frankly, between whistleblower incentives and the DOJ's own stepped up proactive efforts, the odds that a decision not to disclose or even a failure to identify certain conduct within a company will preclude the government from scrutinizing that conduct are really decreasing and continuing to decrease every day. So those are the 3 points I'd probably highlight off the top of my head, Gustavo, and I'll hand it back to you.
Thank you, BJ. Certainly 3 most important highlights. We just heard a few minutes ago with the previous panel from Lorinda Laie from the DOJ about how important it is for companies to be proactive in cooperating and in fully cooperating, I should say, when these investigations arise. But coming back to your comments on international cooperation between different authorities, I would ask if you can expand a bit on that, how that actually operates in real life cases. Maybe if you can bring some comments also related to your experience with the UK SFO and the FCA, that would be great.
Sure, happy to do that. Let me even broaden it a little bit further and just talk in general for a minute about our the cooperation that the DOJ and the SEC engage in. So before even international borders are crossed, I'll obviously defer to Mark to provide thoughts on this from the SEC's perspective. But the short answer of how cooperation works, not just between the DOJ and its counterpart agencies, both on the criminal and the civil side here in the US, but also overseas, is that the DOJ does so very well and has a significant track record of doing so successfully at this point. Thinking just for the moment about the SEC, for example, there are really close relationships between some of the individuals that Mark referenced and supervisors at the Department of Justice, particularly in the office from which I not too long ago left, the fraud section in the criminal division. These are close relationships that have grown up through years of working cases together. Now, it's obviously important to realize that while DOJ attorneys and SEC attorneys, or DOJ attorneys and overseas enforcement authorities are working cases very closely together, there will and should be separation between them. You may hear them emphasize that in your conversations with them, the extent to which they're investigating in parallel and not jointly. That, of course, imposes certain limitations on what the agencies can share with one another. But again, the extent to which the folks at the DOJ, the folks at the SEC, and the folks at many other agencies around the world have worked together over many years on many cases means that they're very familiar with those rules of the road and are able to, very closely and very effectively work together without running afoul of those prohibitions. In terms of international cooperation, again, we'll defer to Mark to touch on the SEC's international cooperation, but for the DOJ's part, there really is, as I mentioned a moment ago, an exceptional and ever-growing amount of international cooperation. I mentioned the Goldman resolution a few moments ago. I believe that was the largest number of foreign counterpart agencies involved with the DOJ in a corporate resolution in history. And so, again, that's just one example of a case where the DOJ showed its ability to coordinate that sizable number of agencies in different countries and landing a resolution alongside one another. That really just doesn't happen without a solid partnership and relationship with those foreign counterparts. And as you alluded to, Gustavo, I'm actually living proof of that. I'm living proof of the value and the commitment that the Department of Justice places on its relationships with foreign counterparts. I did, as you mentioned, spend 3 years over embedded at the Serious Fraud Office in the UK, or excuse me, 2 years at the SFO in the UK and a year at the Financial Conduct Authority, precisely because the Department of Justice places such a high value on its ties to its relationships with those key agencies in the United Kingdom. So again, the takeaway really is just that it's critically important to appreciate that the DOJ is in regular communication and cooperation with its counterparts around the world, both bilaterally and multilaterally in forums like the OECD. And that's going to give the DOJ, extremely robust situational awareness and coordination capability in its investigations. So with that, let me hand it back to you, Gustavo, or over to Mark.
Thank you, BJ. I mean, following up on that topic, Mark, you have been with the DOJ, most recently with the SEC. So what can you tell the people in the audience, particularly in-house compliance officers, in-house counsel, about what it means in real life, the fact that the SEC and the DOJ are cooperating in one of these investigations? How should that be handled? I mean, what it means when devising the strategy on how to talk to the authorities, what it means in terms of understanding how these two authorities conduct investigations. Should companies expect both of them to work together in coordination, but independently? Should companies address both of them in the same way, kind of in a joint talk? You have dealt with these issues in practice. So what can you tell, again, in-house advisors who are listening us in the audience right now? And I would also like to hear from you in terms of international cooperation between these authorities and other authorities from other governments in the world when conducting these investigations.
Now I wish I took some notes on all those questions that you put together, but let me see if I can do this. So first, from an in-house compliance perspective, look, I think there is a lot of advantage from a company perspective to know that agencies within the United States are working together, and as BJ quite correctly said, are working often on a parallel track. They have their own separate investigations, they have their own separate mandates, but they're going to be conducting interviews together. The fact gathering is going to be coordinated. Often the fact presentations by company counsel will be done with both the SEC and the DOJ together in the room. There are a lot of efficiencies for company counsel from a cost perspective to a timeline perspective in doing it this way. I think there's efficiency for the company to work and keep US regulators on the same timeline to try to achieve a global resolution. Often we see in global resolutions that disgorgement amounts paid by a company to a regulator are credited off amounts paid to another country regulator or even another US entity. And this is because, while misconduct being punished by different regulators may be overlapping, the mechanism is put in place so the company is not really paying twice for the same thing. They're getting credited for different amounts, and that inures to the company's benefit. It's also often the case that it's in the best interest for the company to have an all-in-one settlement where they can guarantee themselves global peace for a particular issue and put it behind them and move on. It makes sense from an economic perspective because, the way it should work, internationally and domestic, regulators would be in coordination to determine what a total penalty amount should be, what's that appropriate amount that should be in the pot, and then divide that amount up to allocate it among the different sovereigns implicated by the misconduct. Another advantage, as outside counsel, I'm often trying my best to limit my clients' media exposure. The media exposure on these issues is typically not good, as we all know. So a global resolution perhaps results in headlines for 1 day or 2 days, but it's not spaced out where a company's name is continuing to be dragged through the mud by media because there are seriatim resolutions that happen over months. And I think that's something that outside counsel should prioritize in these resolutions. So the fact that the regulators are working together, certainly an advantage to the government. You have really smart people like BJ at the DOJ. You have skilled folks at the SEC that bring their expertise to bear. And when they work together, that inures to the government's benefit, but also a lot of benefits to the company, and in-house folks as well should be reaping those. One last point I'll just say about international cooperation, it has skyrocketed over the last decade or so, probably from the time that I left DOJ in 2014, even to the time that I went back to the SEC in 2017. I feel like they moved forward in leaps and bounds. You would be hard pressed to find an SEC press release, whether it's on FCPA, market manipulation, accounting issues, that does not, in the last paragraph, credit a regulator overseas somewhere. You see it more and more, not just in anti-corruption cases, but in many of the matters that the SEC brings. I feel that they've gotten much more sophisticated and work really well with their international counterparts, and they frankly have to. Trading is international. The financial markets are not confined to the United States. And obviously with FCPA cases, it's critical that they have overseas cooperation.
Thank you, Mark. So following up on those words, you're bringing to the conversation a number of real-life situations. I mean, how interviews are conducted, how you think of a strategy, trying to minimize, let's say, public exposure about a settlement. So along those lines, which are, in your experience, the usual mistakes that companies make when dealing with the SEC and the DOJ in these kind of cases? These situations that you see happening over and over again, and that can be somehow addressed beforehand, provided that you have the know-how on how to avoid them.
Yeah. So there are definitely best practices, and there are definitely mistakes and pitfalls that can be made. Two words that come to mind when I think of how outside counsel should conduct themselves to get the best resolution for their client, both begin with the letter C, and that's cooperation, and also credibility. And when I say cooperation, I don't just mean sort of complying with a subpoena and document requests. Really going out of your way to try to help advance and assist the government conduct its own investigation. So some things that come to mind: be flexible with an investigative plan. Find ways to demonstrate to the authorities your flexibility and your ability to adjust. I remember, when I was meeting with company counsel, and they told us that they needed to have another 3 weeks for a document production, and questioned as to why. And they said they needed to revise certain search terms because in the course of their internal investigation, they realized that certain, coded words were being used. And so they modified their search terms to pick up additional relevant documents. That's something that stands out to me because it shows sort of creativity and a willingness to really want to cooperate and be flexible in an investigative approach. I think, fact presentations that are given to the government should be fairly neutral. Give them the facts. Obviously, if there are some bad facts, it's counsel's job to be an advocate, and you want to put those facts in context, but don't over-advocate during those factual presentations. Stay fairly neutral. There's going to be a time for your position piece at the very end where you can have your advocacy. When you're going over your investigative plan, make sure the government sort of buys into the pace of your investigative plan. You want to know up front whether they think you're going to be moving too slow, and you certainly, don't want to go too fast and miss things. Just some quick mistakes that come to mind. And this goes back to credibility. And it's the most important word. Don't make representations to the government that you cannot support. And I'm not even talking about intentional, misrepresentations. Of course, that's off the table. But even unknowing representations, if you don't have the data to support your assertions, you can't make those representations. And if you haven't gone through the data to make sure that it doesn't sort of undermine or conflict with what you're telling the government, then stay silent for now. Your credibility goes a really long way. The government doesn't like surprises. Press releases, it's a good practice to let them know if there's a big company event that's going to happen, so they don't read about in Bloomberg. If the CFO is going to be let go, that's something that you may want to have a good relationship with your prosecutor and give them a heads up. As a prosecutor, and I suspect BJ, would agree, we never had a concern about being over-informed by a company of material events that may hit the news. We'd like to know those in advance. A few pointers, I'll end with on sort of, your ultimate presentation to the government. Often, you have a final meeting where you get to pitch your case as to why the penalties should be lower or the charges should be different, or no case should be brought at all. Things to think about when you have those meetings and mistakes that I've seen made. Threats that we will beat you at trial, those often sort of fall on deaf ears. Taking sort of shots at, the staff or the prosecutors in front of supervisors, not great, notwithstanding how sour the relationship may have become. You're not going to get any mileage out of that. Concessions, I think, are important in those meetings. Don't be afraid to admit a bad piece of evidence. Acknowledge, that there are some emails out there that are pretty bad. Again, this helps maintain your credibility. And last, I'll say, listen. From an SEC perspective, listen to the staff. From a DOJ perspective, listen to the trial attorneys and the prosecutors. It's their concerns that really need to drive your responses. You may have a view and an agenda, but if you just sort of go on speaking and you're not hearing their concerns, you're actually not doing the best for your client.
Thank you, Mark. Those are certainly the kind of real-life situations we enjoy discussing at this conference. So, BJ, going back to you, what can you add to Mark's comments on best practices and pitfalls for companies in practice when dealing with the DOJ in anti-corruption enforcement?
Yeah, so obviously I agree wholeheartedly with the points that Mark made, and I'll circle back to especially sort of credibility in a minute. But I want to just step back for a moment and just remind folks, there is a fair amount of transparency from the Department of Justice in terms of expectations of companies investigating wrongdoing, right? So this is not a trick as to how and what the department expects from companies. There's definitely been a push, particularly in recent years, to provide the business community, provide the public more broadly, with clear and predictable guidance on how the department's going to approach its corporate criminal investigations and what it expects. A key part of that transparency is, of course, the corporate enforcement policy, which I'm sure this audience is intimately familiar with. And it's sort of the three legs of that stool that position a company to obtain sort of the maximum benefit available to it under that policy. But I want to take a moment to just highlight one other policy that folks might not necessarily think of in the same breath, but is very, very important and does come into, again, brings into play that point about credibility. And that's the so-called anti-piling on policy that the department issued. And it essentially, as I'm sure folks listening know, requires prosecutors, wherever it's possible or practicable, to ensure that the penalties that they're imposing on a company are not unfairly duplicative of penalties imposed by other agencies. And so to coordinate with, other agencies that might be investigating in parallel. The takeaway from that policy is that it is not, and there have been public pronouncements from various department officials on this point, is that it is not intended as something to be used offensively by companies. That's been explained by others within the criminal division at the department as referring to situations where, for example, a company might go resolve sort of as a strategic matter with one regulator or an overseas authority or something like that, potentially on an incomplete record, you know, and in a way that doesn't thoroughly and comprehensively account for the full scope of wrongdoing, and then come to the department and essentially suggest that because of that incomplete resolution, the company should essentially be given a declination or something else. That is not something that the department is going to look favorably upon. And more importantly, the department is very vigilant. I think, again, you can draw from the fact that there has been, you know, a not insignificant amount of public commentary from the department on this point, that the department is on the lookout for it. And so, again, to come back to Mark's point about credibility, a big part of that credibility is going to come from engaging with the department on that point about, you know, the potential unfairness of duplicative penalties in a way that positions the department and positions the company to benefit from that anti-piling on policy, to come to the department in a way that allows it to coordinate with whatever these other resolutions are. This isn't just me talking, this has happened. The department was very explicit in a resolution last year with Beam Suntory about this very point and the extent to which the failure by the company to coordinate its resolution with the SEC and the Department of Justice led to the Department of Justice taking the steps that it did. Last point on this transparency idea, though, is just that, you know, it's not just the department making promises in terms of how it's going to approach its investigations. It actually publicizes, of course, in the resolution papers with companies, you know, what the company got in terms of credit and why. And so, again, companies do have these guideposts as to, you know, what sorts of steps are important to the department, what amount of cooperation, what cooperation means, and things of that sort. So, you know, with respect to where companies can go wrong, what you'll see if you were to go through those various resolution papers is a variety of reasons, and Mark alluded to some of them, you know, reasons why companies might go wrong in engaging with enforcement authorities. I'm just going to touch on one in addition to the point I made about the anti-piling on policy, and that's, again, to echo something Mark said, which is cooperation. Right? It just can't be overstated the extent to which the department expects full, complete, and what that means is proactive cooperation. And look, that can be extraordinarily challenging for a company, particularly in the context of a sprawling multi-jurisdictional investigation, all the more so when the Department of Justice is not the only enforcement agency in the room. Where there might be multiple enforcement agencies in multiple parts of the world looking at the company. So it can be a very challenging thing to do, but it can, you know, the department is going to have significant expectations around what the company's cooperation is going to look like, and is going to, you know, reward or not reward companies for meeting those. So again, I mean, to me, the takeaways for, you know, the audience would be, you know, that again, there is a lot of transparency out there between policy pronouncements from the Department of Justice and then what you see in the actual resolutions. So the department is not only talking the talk, but walking the walk in terms of what it does when it comes to crediting things like cooperation. But there is still a lot of room to get it wrong. And so, you know, again, companies need to make sound and well-informed decisions to get it right, and need to do so, as I think I mentioned earlier, on an aggressive timetable, given the proactive approach that especially the department's anti-corruption prosecutors are taking nowadays. And again, the rewards of getting it right are really clear and quite tangible. Again, the corporate enforcement policy, as I said, contemplates outright declination of prosecution, where those three requirements of it are met. So certainly a critical thing to get right. And something that I would encourage companies to you know, think seriously about positioning themselves to make those very key decisions on as timely and aggressive basis as possible.
Thank you, Vijay. That's certainly a lot of significant information. So we still have 2 minutes to go. So Mark, I will ask you for some closing words for the panel. Again, in regard to any comments you may make on points that we have not touched yet in regard to how companies deal with the SEC, what these kind of cases mean, the kind of situations you see in real life and that should be kept in mind when companies face these cases?
Yeah, I guess I would just say that from an SEC perspective, one thing that is important to keep in mind is that unlike the Department of Justice, the SEC's burden of proof is only a preponderance of the evidence. And when you think about that, that it's more likely than not, that something has occurred, right? It's sort of 51%. And when they can proceed on these types of actions, not under the anti-bribery provisions, but on, books and records and internal controls provisions, they don't need quite a lot in order to tell a story about bribery without, potentially proving that bribes actually took place when they look at the books and records only. And so, when you think about that and the uptick in whistleblower awards that are out there and the whistleblower program, as well as the aggression of the staff attorneys and the skill sets that they have, I think you're going to continue to see a heavy flow of these cases out there. And it's important for companies to just be very vigilant about their programs internally and obviously consult as they need to with outside counsel.
Absolutely. I'm making a note here about books and record as a topic for a future panel, okay, in a future edition of the conference. So that being said, we ran out of time. Thank you both, Mark and BJ. We truly appreciate the kind of experience that you have shared with us. We are coming back in a minute for the next panel.
Thanks very much.
Thank you.
Bienvenidos a nuestro próximo panel. En este caso tenemos dos invitados con los que vamos a conversar sobre cómo estas investigaciones por corrupción impactan la vida de las personas humanas, impactan la vida de los individuos y cómo se hacen reales más allá de las cuestiones legales que discutimos y de los aspectos que tienen impacto sobre la sociedad en general. Para este caso tenemos dos invitados, Richard Bistron y Red McKern, a quienes vamos a presentar inmediatamente después de este video que va a dar contexto al panel y a lo que vamos a conversar.
Let's talk about the dark side of international business. Richard Bistrong is a former corporate executive who was convicted of international bribery and served more than a year in prison, but he cooperated with the government and went undercover to expose other crimes, and he is now an anti-bribery consultant, and we appreciate you joining us.
You run this firm right now, but one of the reasons you run it is because you were involved in a corruption scandal, you were a wire for the feds, you served time, and now you do consulting.
So
on
what
this.
would have stopped me? That's the one I had 14 and a half months in prison to think about. I didn't appreciate that just by nodding my head, I've created liability across the entire enterprise.
So how about we use our time together to surface some unknowns and make some difficult issues discussable?
So to quickly summarize what we've seen in this video, Richard was a successful business executive who was convicted for violating the FCPA. Ren was the FBI agent, or one of them, leading the investigation and leading the case to prosecute Richard. Now, Richard has become one of the main advocates of anti-corruption and compliance, I should say, around the world. The purpose of this panel is to hear from them what these kind of cases look in real life and how they impact the life of individuals. That being said, Richard, Ren, thank you both for joining us today, and it's a pleasure to have you here. On that note, Richard, can you please explain to us what happened? You were doing really good as a successful business executive. You are a well-educated person. What happened for you to end up facing the kind of situation we saw in the video?
Well, thank you, Gustavo. It's a pleasure to see you and Ren, and thank you to the Marval community for the opportunity to join you here today. So, Gustavo, as to how this story went so wrong, let me, first of all, I need to share, and I hope you won't turn my video feed off, but it all started to go wrong in Argentina. So I just want to level set that first. And to date it a little bit, this occurred around 1997. So what happened is I was an international sales executive, but before that, I was a US sales executive. So the first half of my career, I'm focusing on the US market, right? What we might consider to be low risk, lots of opportunity, a great sales environment. And then in 1997, for this large publicly traded global multinational, not dissimilar to the companies that are joining us here today, the company's looking to invest in emerging markets, not just stable ones. And I was really anxious to start looking at that as well. So I then get the role of the international sales vice president of this multinational. Lower in opportunity, more high risk, high reward, and a much different risk-facing profile. But Gustavo, before I take my first flight, and as I'm sure you can imagine, I was very excited about this new role. My former employer presents me with the FCPA. Right now, again, I'm going back to around 1997. And they said, Richard, this is the law that's going to govern your conduct in your new role. And let's remember, and we might come back to this, is especially in this environment, people are changing roles all the time. And maybe we can talk about the risk that brings. But they were very clear. They're like, you need to understand this law, take your time and read it, because it's going to govern your conduct. And if you have any questions or need resources to help you understand it, we'll get you them. So I know the US criminal code is very complicated, but even to the former commercial Richard, the FCPA is rather simple. You can't bribe to either win business or retain it, either on your own or through a third party. And Gustavo or Ren, if I had that wrong, please correct me. So I signed that paperwork and off I go. Now I'm going to build my market and my marketplace through partnerships with third-party intermediaries. And I'm going to use that word very broadly. That could be a distributor in some cases, an agent, an intermediary, it might be a reseller, but essentially, like a lot of multinationals, I'm working in partnership to develop business. Very early on in this new role, I'm meeting with one of my business partners in Argentina. And Gustavo, we're talking the south part of Argentina, more precisely Tierra del Fuego. A fascinating place to visit. And I'm there talking to one of my channel partners that I had no indication was corrupt or, Gustavo, even corrupt intent. He had a bank account in his name, in your country, and he was doing all the things you want your responsible business partners to do. Identify market opportunities. My Spanish isn't great, so he was translating documents where necessary. I was selling armored vehicles and armored systems, which were very complex in technical sales. So he was introducing me to end users to do technical sales presentations, all responsible business practices. And we had done some small deals in the past, but I'm not in Tierra del Fuego to talk about a small public sector procurement. I'm there to talk about a rather large upcoming one. And he starts to talk about how we're going to win this. And I'm very nervous. I'm in this new role. And he said, Richard, calm down and relax. We're going to win this piece of business. He said, because as part of my success and my success fee, because as we know, third-party intermediaries aren't making any money unless they're winning business. He said, I'm paying tolls to win the business. Now, Gustavo and Ren, I grew up in New York City. I know what a toll is, right? If you're crossing a bridge or going through a tunnel, you're paying for the right to access. And in Tierra del Fuego, I didn't see any bridges or tunnels. I knew what he meant by that toll, right? And in the next 15 years, I'm going to hear so many different and interesting words to describe a bribe, from making people happy to taking care of people, sunshine payments, and I don't know why food is a favorite, but I've heard them called cakes, candy, marzipan. The only word that I'm still waiting to hear to be used to describe a bribe is bribe, right? And by the way, there's a little bit of moral fading that occurs when you hear these words. I think if you would have said I'm participating in transnational crime, I might have had a different reaction. But again, this is a story of personal accountability. So these decisions, just to be clear, were no one's fault but my own. But anyway, look what he's doing. He's intertwining corrupt and legitimate business services. He's doing all those things that we want our responsible business partners to do. But if it's necessary, he'll pay tolls to win the business. And I think the reason why I remember that conversation like it was yesterday, beside the fact that it took place in Tierra del Fuego, which is a beautiful place to visit, is he wasn't asking me for anything. He wasn't, as you know, Gustavo, the money has to come from somewhere, but he wasn't saying, I'm paying these tolls and I'm telling you about them because I need a bigger commission or retainer or marketing rebate. He wasn't asking me for anything. He was just sharing. Take a deep breath and relax. You look a little bit nervous. We're going to win this business because this is how we get it done.
So that's a clear scenario, right? But I mean, Richard, if you knew these conversations were approaching a violation of the law, why didn't you ask for support? Why didn't you speak up? I mean, was it that you underestimated risk? And how may companies face this kind of situation? Try to encourage people to actually speak up, ask for support, and find a way out.
Well, that's a simple and quick answer is when he told me about this, I'm just thinking, this is only a problem and a red flag if I make it one, right? And who am I to get between this country and what were life-saving products with great technology, bullet-resistant vests and vehicles, who am I to get between this country and my company and a huge upcoming order? So, just by nodding my head, just to be clear, I knew I was violating the FCPA right there. And that's not ultimately what I went to prison for, and we can talk about more later about that. But Gustavo, I was just trying to figure out risk while I was in the middle of it. I knew that I was violating the law by nodding my head, but I also thought I was in the middle of competing corporate objectives between that pressure to succeed and the pressure to comply. So I underestimated risk, because what I was calculating was what my bonus was for achieving those rewards, goals, and objectives.
Quite clear. So, Ren, in your experience as a former FBI agent and a current expert on anti-corruption, have you seen these kind of patterns, just as Richard described, this sort of slippery slope, things starting small and getting much bigger? Have you seen this happening, repeatedly? Is it, in your experience, how corruption situations begin, or does corruption simply begin big right at the outset?
Yeah, thanks, Gustavo, and thanks to Marval for putting together the summit for the 4th year in a row, and always a pleasure joining Richard on a virtual stage. But it starts in lots of different ways, but I think if anything people should take away from this panel is this is about people, right? And the people that you hire in your organization often change, right? People go through different stressors in life. Can't be more apparent now during the pandemic, with all the pressures, maybe financial, maybe family, maybe you have to take care of family members, maybe you have to take care of your kids. People are losing jobs, people are losing houses. People are having to deal with different stressors and challenges, and they may also be upset with their work environment. So they're making decisions, what we call compliance decisions on the fly, I think Richard used to say, and making those decisions, thinking about themselves based on what those pressures look like. And so one of the things we talk about is, are you checking in with your team? Are you checking in with your people? Compliance professionals around the world, we look at data, we look at all sorts of nice pieces of information, but we don't really talk to a lot of people like we should, and we don't really know exactly how folks are handling it. Everybody's different, right? How you check in with somebody, how you find out if they're doing okay, how you know if everything at home is okay, how you know that they're feeling supported is critically important, and that people feel that they want to be a part of the organization, and that if they need help, they can find it, and that people are reaching out to them proactively in a way that is good for the company, is good for the people. That is what's most important here. What I think we most often saw was people maybe did one thing to take care of one issue. They thought, if I could just take care of this one contract and win this one deal, I'll make sure I get my bonus, and then I'll fix it. I'll never do it again. I just had a tough year. I just got to do whatever I have to do. And then maybe they do that successfully, and then they're like, well, next year, different pressures, and they do it again. And what we know is, over time, they're empowered by the fact that their behavior is not being detected. In their actions, and then start to justify to themselves personally what they're doing is good for them, because they have to survive, they have to keep their house, they have to hit their number. It's good for the company. You heard Richard just rationalize, it's good for the company, it's good for the organization that they're dealing with. People rationalize this behavior all the time, and so you have to check in and make sure you understand your people, and everybody's looking out for your people. Remember, people are your greatest asset, right? And what are we doing to protect them? That's the way to think about it.
Well, I fully agree on that one. Certainly from my experience, which is quite different and coming from another part of the world, it's all about people, just like you have described. But when it comes to the fact pattern that Richard was describing, he's also bringing up the issue of third-party intermediaries, one which is kind of a classic in compliance and anti-corruption. But we are not talking about a bagman, coming up and asking for a certain amount of money in exchange of getting a specific result. This is somebody who shows up in a way arguing to add some value, let's say, to the business. What is your view as an expert in this field and having conducted so many investigations on how to deal with third-party intermediaries, and how can companies address that very specific point?
Well, we talk about two-factor authentication all the time from cybersecurity standpoint. I think you need to think about two-factor authentication when you're dealing with high-risk third parties, right? You need to have another objective party that can look at the deal and really break it down and understand what's going on there. It's almost like that famous nuclear situation where people have two keys, they've got to turn them together in order for the missile to launch. When you're dealing with high-risk third parties, you need to trust but verify, and you can do that multiple ways, but you also need to check for conflicts of interest. You need to make sure you're separating responsibilities. This is also about getting the money out, right? They need to find a way to get the money out of the company and get that bribe payment over to that government official eventually. And so I'm making sure that your audits are in place, that you have audit rights with your third parties, and that their third parties understand that they are under the authorities of the Foreign Corrupt Practices Act, despite that they're domiciled in another country. They need to understand what's at stake. Remember, these third parties depend on the company to be successful. They want that big brand. And they're willing to sign any paperwork just to win the deal, to be that third party. But you got to stay on top of those folks. You got to do your risk assessments. You got to check in with them as well. And you also have to do your diligence. Without all of that, you're going to find yourself in a tough position every time. And then remember, when things change on the ground, you also have to re-examine third parties. So if there's a change in let's say, political winds of change are occurring in a certain location, that may change your third party's ability to win work. And so if they're no longer in the power group, if you will, they may have to do other things like pay bribes so they get the new business done again. And so you have to be very aware of what's going on locally in order to understand your third parties.
All right, so Richard, going back to the situation that you described, I mean, when you were presented with this proposal, let's say by the intermediary, did you think, well, this is how things are done here, I'm not going to be stepping out of the way? Did you think that the company was going to lose business? And how did you address this situation? What may companies do in general to address this particular line of reasoning? If we don't follow these kind of procedures, we are going to be losing business. And as an executive, I'm here to win business. So what can you tell us about that in your experience?
Well, I certainly had that mentality. Even though I worked for a great company with great brands and disruptive technology, I had a status quo mentality, right? And I let what was immediately important, like my goals, my objectives, and my awards and deadlines, overwhelm what was fundamentally important, like ethical and sustainable business practices. So sadly for me, and totally avoidable, I chose the bribe over the brand. So how can we prevent that? I think there are a few things we can do to address that mentality. Number one is look at the side effects of your incentives, your goals, and your rewards. And think of side effects like prescription medication. If you turn the bottle on its side, you're going to see those side effects. All incentives have behavioral side effects. And are they aligning with your goals, your values, your purpose, and your mission? And what studies have shown is that compliance leaders are not often enough involved in those incentive discussions. You need to be at the table. And to remind teams that they are the guardian and gatekeeper of the entire organization's codes, policies, and values, including the organization's reputation as an individual. Help them appreciate their role as the guardian and gatekeeper to the company's reputation. And also help them understand what the wider ethical implications are on their decision making. I mean, we're talking about Transparency International. Get them to understand, help them to understand how even small bribes impact economic development, human rights, health and welfare. There's a great book in this compliance library called Blind Spots. And what it shares is that when we think of compliance as just policies, rules, and procedures, that it distorts our behavior instead of helps it, because we think if there's not a rule for a particular interaction, it means that it's permissible. And we certainly don't want people on the front lines thinking that. So I think if we could just help people appreciate that there are always workable alternatives to success, and that any challenge can be unpacked as a team, and that the only problem that you can't help your business peers with are the ones that they're keeping to themselves. So it goes back to what Ren said, proactive outreach, let's hold each other accountable.
Absolutely. And also going back to what Ren said, I mean, Ren, what can you tell us, again, as a former FBI agent, as an expert in this particular field, to those business executives who are facing the same kind of pressures that Richard felt? And the pressure to win business, the pressure to keep things going as they have been going for years. And particularly to those who may be facing exposure to regulations like the FCPA, but are operating, let's say, far away from the US, and thinking that maybe that's too far away, and that means that evidence will not be obtained. That means that nobody will really care about what I'm doing because, again, I'm in this remote country in the world. What can you tell those people?
Yeah, it's a great question, Gustavo. I think, Richard hit on it earlier. He knew the very moment that this gentleman said you're going to have to pay tolls, that he was crossing into another world of business. At that point, when executives, other folks in the company, in the organization they're very aware they're crossing over. They need to go and find the people that they love and surround themselves with their values and things that basically keep them, happy, their warm fuzzy places, if you will, because the reality is going to federal prison is horrific, even if it's for 6 months or even a year. It is devastating, and you will lose everything. You will lose your standing in your community. You will lose your family. You will lose your marriage. You will lose all the assets that you worked hard for. It's supposed to be that way, right? Jail is supposed to be unpleasant. And so checking back with your values, checking back in with your company, anybody that you can bounce something off of, you need to do it. You need to pull out the mirror and take a hard look at yourself and say, what am I doing this for ultimately? Because you're going to end up in jail likely if you hear about the scenario that Richard just described, and he found himself in federal prison. It's not a kind place, so you have to stop. It's very difficult because the pressures are there, but it really you have to play to the emotional side of where things and how much you have to lose. It's incredible how much people lose just to try to get ahead just a little bit more, and that's what you need to do is really is look in the mirror.
Yeah, and you're touching on the very essence of this panel, which is what happens to individuals in real life when they get exposed to these kind of cases. And I should add, most likely from the point of view of most Latin American countries and some other regions of the world, that let's suppose that you don't even get to go to jail. Being subject to an anti-corruption investigation for over 10, 15, 20 years, believe me, will most likely bring the same kind of effects that Ren has just described for those who are convicted in the US. I mean, you will lose your assets, you will most likely lose your marriage, and the impact in the personal life will be huge. We will talk a bit more about this by the end of the panel. But Richard, let me go back to you and ask about the investigation. So you were the subject of an investigation by the US and the UK authorities, right? Which I assume was a unique experience. What can you tell from your side to the investigators and authorities which are watching us right now?
Well, I agree with Lorinda that the teeth of international law enforcement are very real, as I was subject to a carbon copy prosecution in the US and the UK. So very briefly, the way I got caught, and we still see this very much prevalent in our anti-corruption community, is I wasn't calculating risk, right? Ren talked about optimism bias, where we think that we're not going to get caught. What I wasn't thinking about is what would happen if one of my third parties got caught. And that's exactly what happened in the United Nations Oil for Food investigation. And in a long way, you know, I was one of the spokes out from that third party in a defense contract. I ended up getting targeted first by the US law enforcement authorities, then by the UK law enforcement authorities. But I think what I'd like to share here is the first part of this crucible started with an internal investigation. And the internal investigators on my case acted like they were prosecutors. They wanted that gotcha moment. They wanted to catch me in my own words. And I was ready to cooperate. I mean, when I got caught, I was like, I did it, and I'm not going to delay justice. I actually want to face justice and start a new trajectory of my life. But they made it difficult because you could feel the pressure. There was yelling going on. And even though I wanted to cooperate, it certainly didn't make me want to cooperate. That internal investigation did not go well. Then counterintuitively, 3 months later, I get targeted by the Justice Department. Now I find myself in the Bond building in Washington, D.C., in front of the FBI and the prosecutors at the FCPA unit. They were acting like journalists. They were asking me very open questions. They were very clear that they didn't want to find a gotcha moment. They wanted to hear what I had to say. They even shared, Richard, if you're struggling with your memory on a particular question, because we know it's not like you had to leave your company with all your files, we'll even try to find emails to help your memory. And there was such respect there, even though we're sitting on opposite sides of the conference table, so to speak. Gustavo and Ren, they made me want to cooperate. The fact that they showed respect and I showed respect, even though it was sort of an adversarial meeting, it was one that relaxed me. I realized that they were out for the truth, whatever that might be, and they really made it easy for me to talk. So I really think we should think about that when you're sitting across from the former commercial Richards, scared and anxious. There's a way that you can get us to help you, but it's going to take a little time.
Well, that's certainly a lot to say. And as a result of what you have described, this should be a lesson learned for people conducting internal investigations, right? I mean, there are different ways of doing it, but certainly there are ways that could make them closer to actually finding the facts and obtaining evidence, which should be the purpose of an internal investigation. So, Ren, you have extensive experience in this regard, both with how internal investigations are handled and investigations by the authorities. Some words that you can share with us about this particular topic.
So interviewing is the most important part of an investigation. We spend a lot of time at the FBI training for that. And I've interviewed some terrible people, serial rapists, murderers, terrorists. But I didn't get upset during those interviews. I prepared. I went in knowing that I had my documents lined up. I had my facts lined up. The importance of an interview is that you only have one shot to talk to that person, even in an internal investigation. And so you want to make sure you take advantage of that. And when you want to go in, you want to understand what is the value proposition of that person. You want to build rapport. Rapport building is everything. Spend as much time as you can talking about everything but the investigation. Get them comfortable. Get them to understand that you're just doing a job. Just got to ask some questions. It's not personal. Even though you may be really upset that this person likely stole, paid bribes, defrauded the company, You have to put those feelings aside and act like you're their best friend. You need to get them comfortable. That technique, that rapport building, understanding what's important to them. I'll often look at somebody's profile before I go in, and if they have something like, okay, they like to watch baseball, great. Then I can talk about baseball. They want to talk about basket weaving. I'll go look up basket weaving and talk about how I always want to learn basket weaving in college, right? Anything to break the ice, get them comfortable. Spend as much time you can to do that, and you will get much better answers to your questions. If a good interview will save you so much time and energy and money, it's well worth the investment on rapport building and in preparation, of course.
Well, that's certainly valuable know-how to anyone, again, conducting internal investigations. So we are approaching the final part of the panel. We still have 5 minutes to go. And Richard, I want to go back to you and address, again, the main purpose of this panel. If you can further tell us how this situation that you went through actually impacted your personal life and your family. And as a second question related to that, what was the reason for you to decide to have these kind of conversations like you're doing right now, sharing what you went through, which I assume was not a nice moment in your life, with thousands of people? I mean, and you do this in so many conferences. So please tell us a bit about that.
Well, as you both have addressed, it had a catastrophic impact on my health and my family. When my case went public, I mean, it was front page of the New York Times. It was the entire front section of the local Sunday newspaper. So at a time in my children's lives where self-confidence and awareness was already fragile as young adults, I mean, they really had a difficult time. And so all the people that I thought I was helping, like my company with these big orders, my family taking my children on fancy vacations all over the world, those were the people that I hurt the most. And I couldn't agree more with Ren, is encourage people to stay close to their loved ones, to listen to their voices when they face an ethical dilemma, because if you make the wrong decisions like I did, those are the voices that you can lose. And as Ren shared, federal prison, even for a short sentence, is not a pleasant place. So I know the three of us share a passion for running. I walked into prison a 13-time marathon runner with a small cholesterol problem. And in prison, you don't have the access to a good diet or a lot of exercise equipment. And when I got home and I'm all ready to start training again, I felt a little chest pain. And before I knew it, this little cholesterol problem that I had in my life was full-blown coronary artery disease. And within months of getting home, I had to have an emergency heart procedure. And that's just 14 months. So it was catastrophic due to no one's fault but my own. And the reason why I still share this story is because the issues that we've been talking about are still stubborn, they're persistent. We still have people on the front lines of operations thinking that they're in the crosshairs of those competing corporate objectives between the pressure to succeed and the pressure to comply. And people might think, as Ren shared, that just once they might have to sacrifice integrity to succeed. And then we know that's how the slippery slope starts. So I hope if there's one message we can take, it's if someone's not calling you with an ethical challenge that should be calling you, that's in a high-risk region or marketplace, call them. Keep people accountable. No news does not always mean good news. And as in my case, bad behavior can hide behind good performance until it's too late for everyone. Thank you, Ren and Gustavo.
Well, that's a quite clear message, and thank you, Richard, for being so open and direct on that. So Ren, to close the panel, I will ask for your final comments on what would you say to those who are nowadays in a situation similar to the one Richard was facing back then, as he described. I mean, what should they think when they are presented with these kind of situations in which wrongdoing is one step ahead, and they are thinking about the pressure they feel to keep their job, the pressure they feel to keep certain standard of living for the family, and somehow certain appearances.
Well, two things actually. So the compliance professionals, make sure you're checking in on your people. Create metrics for that and somehow have barometers for that and make that a KPI throughout the company. Second of all, to the people that are at the crossroads of going into the dark side and losing their integrity, it's not worth it. Is a simple statement here. You will lose everything, even though you may be 5,000 miles away. You think you're outside the reach of U.S. regulatory or law enforcement groups. The reality now is the world is flat when it comes to enforcement around the FCPA and foreign bribery. They are more aggressive than ever. I think we heard this over the last couple sessions of the last few panels, that you likely will not get away with it. You will be caught and you will lose everything. It's not worth it. Ask for help. Reach out to people at your company, reach out to your family, and get ahead of it and don't do it.
So on that note, thank you, Richard. Thank you, Ren. I should add as my final comment that in addition to sharing his story like he did with us today, Richard, over the years, has gained unique experience on compliance programs and how to actually impact compliance culture at companies. So I suggest you read or watch his videos. I mean, he can easily be found on LinkedIn and YouTube. I mean, the same as Ren. These are two people with whom those in the audience could certainly continue talking about a number of topics that we were not able to cover in today's panel. But that being said, again, Richard, Ren, I appreciate very much having you today with us, and we will be back in 1 minute for the next panel.
Thank you, Gustavo. Thank you, Richard.
Thank you, guys. Appreciate it. Thanks, Ren. Thanks, Gustavo.
So welcome back to another panel at our conference today. And this panel is specifically addressing internal investigations. This is a topic that we have touched upon during the previous panels, but we have now as panelist Sergio Moro, current director at Alvarez and Marval, and the former judge presiding over the Lava Jato case, and former Minister of Justice of Brazil. We also have Cara Brockmeyer. She is a partner at David Boyce and Plimpton, former chief of the SEC's FCPA unit. So certainly we appreciate both of you, Sergio, Cara, joining us today and discussing this topic with us and sharing the kind of unique experience you both have on this matter. So, as a first question, let me ask to both of you, what are the usual mistakes that companies make when conducting internal investigations? Maybe, Sergio, if you would like to go in first.
Oh, thank you very much, Gustavo. Let me say that's an honor to be here on this panel with you and with Cara, and be invited by Marval Faro. I believe a common mistake is not to be prepared. Usually, companies reacted against incidents, and a great part of them are not well prepared before these incidents happened. So when the incident happened, they need to do everything with urgency, and sometimes they commit mistakes. So the best way to deal with this kind of problems is to be prepared. You need to realize that these incidents could happen in every company. So you need to have the protocols prepared before they happen. When they happen, another usual mistake is to try to deny that you have a problem. Try to ignore the problem and not dealing with it with the proper ways. So depending on the level of the incident, the level of the problem, you need to take the proper measures. Usually this will involve doing an internal corporate investigation. Then you need to make a decision if you will do it by yourself or if you will hire a third party to conduct the investigation. Usually this depends on the severity of the incident. Serious incidents, usually we recommend that you hire a third party. Minor incidents you could do by yourself. So I believe the main mistakes is not to be prepared. You need to build these protocols before the incidents start to happen. And when they happen, you will be prepared to follow the protocols and have the best answer to them.
Well, that's a nice starting point, and I certainly agree on that. What we see in practice is that companies not having protocols, usually they don't have the know-how on when, why, and how to conduct an internal investigation, which makes things so much more difficult, because then they will need to make decisions on an urgent scenario without having the know-how or the protocols. So as you said, being prepared will help the most. So Cara, going back to you on the same question, which are the main mistakes that you have seen over your practice that companies make when handling internal investigations?
Thanks, Gustavo. I think Sergio set it up very well, having the protocols in place so you know what the plan is, so you know how to approach things. And also, I think for companies, it's important to think strategically at the beginning. So whether you have a whistleblower complaint, you have internal audit that turned up something that may be an issue, you think about things like privilege. Do we need to figure out a way to have this directed by attorneys so that in the US and countries like the US, you're going to provide the most amount of protection for the internal investigation? I think you also want to make sure that you're thinking very carefully at the beginning about what steps you need to take. Is it, as Sergio said, does this appear to be serious? Does it appear to involve corruption? Does it appear just to involve employee theft? You may want to treat those two things differently, but I know we're going to get into some of the steps that you want to take at the beginning to make sure that you're locking down documents and evidence and texts, and that you're thinking through if this is an issue, if I find myself in front of regulators or in front of enforcement authorities, have I taken all the steps at the beginning so that they don't accuse the company of spoliation of evidence? And am I also thinking through, if this looks like it's a minor issue, have I really thought through all of the issues? So sometimes what appears to be a surface issue, when you dig a little bit further, you realize that there is also something that involves an anti-corruption issue, which, as we all know, puts it in a different category, particularly with the respect to the way that that enforcement authorities think about it.
Well, you touched upon a particular topic, which is critical in internal investigations, at least in my experience or in my opinion, that is most seen, I would say, in legal practice in the US and some Anglo-Saxon countries, but not so common in other jurisdictions like Latin America. I'm talking about attorney-client privilege. So can you please expand a bit more on that, Cara? I mean, what has been your experience in dealing with attorney-client privilege, particularly in cross-border cases? And what would you suggest to do when companies face this situation, and how should they approach attorney-client privilege in the context of internal investigations?
That's a very good question, Gustavo. As you mentioned, in the US and the UK, and a lot of countries that have a similar legal system, you get a lot of protection of the results of the internal investigation if it's conducted under privilege, meaning that it is in the US, it can be conducted either by in-house counsel or by outside counsel. That's not the case in all of Europe. In some jurisdictions, it has to be outside counsel. In-house counsel will not give you that attorney-client privilege. What the privilege allows for jurisdictions that apply it, and the US is one, is that it gives the company control over whether or not they want to disclose the results of the internal investigation to the authorities. And it increases the likelihood that if you do decide to disclose the results of the internal investigation, you're going to get the most amount of cooperation credit that you can give, because you're giving them something that under, for example, US law, they otherwise wouldn't be able to get. They can get the facts, they can get the documents, they can get the emails, but what they can't get is the results of the internal investigation, the putting together of all of the pieces that save them a lot of time. That is really fundamentally for the US authorities and for the Brazilian authorities and other authorities that have developed cooperation models, what they're looking for in terms of cooperation. The other part that, so this is an area where I think if, for example, you are a Latin American company or the Latin American subsidiary of a multinational company, very early on in the internal investigation, if it looks like it involves anti-corruption issues, you want to be thinking about what jurisdictions may possibly have some sort of jurisdiction over this conduct. Who may I find myself in front of? And then you want to make sure that you're consulting with lawyers in each of those jurisdictions, so you're doing the most that you can to protect the company and protect the company's privilege.
Well, you are also bringing up another quite significant point, which is that all of these regulations, and I'm talking about anti-bribery regulations, attorney-client privilege regulations, and so many others that are involved in these kind of internal investigations, they look so similar, but they are not that similar, right? I mean, even the definition of bribery is so different from one country to another. The kind of liability that bribery could bring for a company in a country could be criminal, in another country could be civil or administrative. So that's usually a common mistake I see in real life, assuming that all of these regulations work the same throughout multiple countries. So that comment aside, we have also seen during previous panels today that the collection of evidence is such a challenging issue when it comes to investigation. So, Sergio, can you please describe to us the main aspects that companies should keep in mind about the collection of evidence and the big difference there is between that evidence that they may want to potentially use in court or the evidence that will serve only for internal purposes?
Gustavo, this is a very important point. That's the reason that it's important that you have protocols to deal with problems following the seriously of it. For example, it's different when you want to make an internal investigation just for internal purposes. When you need to make an internal investigation and you are concerned that you need to later go to the courts or to defend yourself or even to litigate against someone who committed fraud against your own company. The problem is that in the beginning, sometimes you don't know the extension of the problem. In this case, I believe it's better to think about the possibility that you need to go to the court, and then you take the proper measures to avoid any kind of discussion about the evidence that you need to collect. One thing that is very important is to have all the records, all the documents of each step that you take. Then you can, even if you need to go to the courts later, you could show all the steps that you took during the investigation and assure that the evidence that you collect is solid and you took all the proper measures about necessary to build a case before going to the courts. I would also like to address a point that was mentioned. There is this trend in favor nowadays for extraterritorial jurisdiction. We are seeing each day more cases when a company, for example, from one country needs to answer an investigation or answer charges before courts or agencies from another country. So this is also a question to be concerned that you need to deal with the problems, of course, depending on the level of the serious of the question. You will need to deal with it before the local authorities, but you also need to have an eye on the possibility that you need to discuss your case before authorities of other countries. Especially, we have in the past, especially cases being built with the FCPA by the DOJ or the SEC in the United States against foreign countries out of the United States, but companies that have business in the United States. But nowadays we have other countries with similar laws. That is the case, for example, of Brazil with the Clean Companies Act. And we saw, for example, during the Lava Jato cases, some foreign companies need setting cases in Brazil involving bribery. So you need to go step by step, collect the evidence, recording everything you are doing, so you will avoid risks of being questioning before the courts. But also you need to be aware that maybe you need to present this evidence not only before your local authorities, but also before foreign authorities in the future.
All right, so as you have described, the situation gets more complex when dealing not only with local authorities, but also with authorities from other countries, which in the end is becoming a more common situation as almost every country in the region and most countries throughout the world are enacting regulations that penalize bribery of foreign officials. I mean, in Argentina, for example, we have our FCPA-like law enforced since March 2018. I mean, not so long ago, right? But as soon as more of these regulations become enforceable, the actual investigation of these cases gets more complex, just as you described. And following up on that point, Cara, what can you tell us about how to deal in real life with this scenario that Sergio has just described, dealing with multiple authorities? I mean, you are conducting the investigation most likely in several countries and collecting evidence in those countries, and then making a strategic decision on whether, first of all, whether to disclose the case or not to the authorities, and then what to disclose, and lastly, who you would talk to first. So which are the highlights of what you have seen in real life when companies deal with this situation?
Yeah, they're very complicated issues. They're much more complicated now than they used to be 5 or 10 years ago. So even with respect to document collection, for example, the authorities, both in the US and elsewhere, one of the very first things that they'll ask a company is, did you take people's cell phones? Were you able to get their texts? Were you able to get their WhatsApp messages? Were you able to get whatever other messaging system they may be using? And this presents its own set of issues depending on jurisdictions, and you may be conducting an internal investigation that involves multiple countries, and you may have local data privacy laws that you have to deal with that are different country by country. So in one country, for example, you may be able to ask people or collect from people their work devices, but not ask them for personal devices that they may also be using. In another jurisdiction, you may very well be able to get all of that. And then similarly, there are likely to be issues with what employment actions you can take against people based on the local laws. And then once you get through all of that, you've collected the data, you've frozen what you can, you've gotten the emails, you've gotten the hard copy documents, you've frozen the OneDrive, you've taken people's phones, or they've given you permission to copy some of their phones and their laptops and their iPads now. And then and you've determined that there's an issue. Then, as you said, Gustavo, the question is, where do you go? So if you're a US company, it's pretty easy. You go to the US authorities first. You may have to go to other jurisdictions as well, but most of the time, if you're a US company, that's easy. If you're a Brazilian company or an Argentine company, you're probably going to go, if you're Brazilian, you're probably going to go to your Brazilian authorities first. You may also have to deal with the US authorities, but maybe not. In Argentina, I'd be actually interested, Gustavo, to see what you say, because the reason why, for example, companies will go to the US authorities is because, first of all, as we've heard from the other panelists, the US authorities expect that if they have jurisdiction over a company, particularly if it's a company that is listed in the US or is a US company, they're going to hear about it first. And they want to hear about it early in the internal investigation, even before you've finished the internal investigation. But secondly, we know what happens when you go to the US authorities. There's a playbook. We know what happens. Typically, if we're cooperating, we'll get time to finish the internal investigation. We'll get time to make presentations to the government. We know what the Department of Justice and the SEC will do in terms of cooperation credit and how they'll assess the fine and how they'll calculate the profit. Brazil, I think, now has, from my perspective, and Sergio, I'd certainly be interested in yours as well, particularly because of Lava Jato, which when I was at the SEC, I got the chance to see sort of the beginning of that, and I was there for the first couple of cases that Brazil and the US did together. Brazil now has that track record, so you know what's going to happen. They have leniency agreements. But Argentina is a little bit different, right? You haven't really the Argentine authorities haven't really brought enough cases. You don't have that same level of confidence that if you go in and you give them basically the keys to the safe, you give them the results of your internal investigation, you're going to get credit for it and what it means down the road. And there's a lot of other countries that are in that, what I would call that boat, where they're interested, they may want to hear about it, but you don't know what's going to happen. And the way that we describe it to our clients is you end up basically trying to play three-dimensional chess, because figuring out what jurisdictions need to be involved and when. Can you treat them differently? Can you give them different information? If the laws are different and impact, one if, for example, the US has jurisdiction over the entire company because the parent company lists in the US, but the Argentina has jurisdiction over a single sub and doesn't have jurisdiction over the rest of the world. So the issues you found in Colombia or Mexico, do you tell the Argentines everything, or do you only tell them what involves them? This is really, I think, where you really need to make sure that you have good, experienced counsel who are used to dealing with these issues, not just in the US, but also in the local jurisdiction. And most importantly, that they can collaborate well together, because a lot of these decisions are decisions that are basically the product of strategy discussions and thought, and a lot of analysis that goes in discussions between outside counsel over what happens if you turn over a piece of evidence in one jurisdiction, but maybe don't want to turn it over in another.
You know, you're touching upon another topic that keeps popping up in different panels throughout our conference, which is working in teams. You know, addressing these matters truly as multi-jurisdictional, truly as bringing together, you know, know-how from different areas of the law and even beyond the law. When you, I don't know, bring on board IT experts to do the forensics on electronic devices, when you bring on board accountants to deal with, I don't know, any books and records issues. But just as you said, having the appropriate team of people to deal with all of the issues that come to the surface is key. And you were also describing another big point, which is somehow predictability. You said, if I go and knock on the DOJ's door, if I knock on the SEC's door, I know what I'm going to get from them, right? I know what they will ask. Usually, I have good guidelines on how they should react. Well, I think that most countries in the region, we are trying to catch up with that. In Argentina, going back to what you mentioned, we already have our, as I said, FCPA-like law. This law brings the possibility of reaching settlements in these kind of cases, which is quite new. Also the possibility of getting credit for having an appropriate compliance program in place. But still, as you described, we have no case law. And certainly, you know, the courts and the prosecutors will have to go and live through all of these cases and see what decisions should be made at what point in time. So the level of uncertainty you would face in a country like Argentina is much bigger than what you have in the US, though the essence of the regulations are quite similar. But my point here is not all of the answers are in the regulation alone, right? So that being said, another big point that you mentioned is when dealing with different governments, I mean, different countries involved in investigating a case. What do you expect those authorities to do when prosecuting the case? What kind of cooperation do you expect them to show? How much should companies be concerned about the capacity of prosecutors, of government authorities to actually work together to carry forward an investigation? Sergio, you may want to comment on this.
Oh, there has been a great evolution on international cooperation in criminal matters and also in civil matters in the last 10 or 20 years. I remember when I was a judge in Brazil in the beginning of the 2000 years. It was we did not have at that time the MLAT with the treaty, mutual legal treaty agreement with United States. So usually we cooperate when it was possible because you know someone who you could connect and ask for some cooperation. And it was very precarious at that time. But later we have the mutual legal treaty agreement. And one thing that's important, it's not only having the agreement or having the proper laws. As I said, the Clean Commerce Act in Brazil was approved in 2013. what is really important is also to develop a practice. Developing a practice, then you will build rules, protocols, manuals, what to follow. And also, when you have usually international cooperation cases open the doors for further cooperation, because the authorities start to meet and know each other, and they start to build a relation of trust. And this is very important in international cooperation. Of course, sometimes international cooperation it's not possible. We have this experience, large experience during the Lava Jato case. Brazil had cooperation with several countries around the world, sharing evidence or receiving evidence, for example. And also, there are some cases that they made settlements, joint settlements with foreign authorities, and sometimes it was you need to build new practice because it was very new. For example, to the Brazilian authorities. But when you started, the result will be probably in the future to have more and more international cooperation. Of course, sometimes with some problems. I remember an interesting example. Some of the Brazilian companies, they made plea agreements, leniency deals with Brazilian authorities, and some of them revealed that they had paid bribes, not only for public officials in Brazil, but also to public officials of other countries, for example, in Latin America countries. And the prosecutors, they wanted to share the evidence with their counterparts in the other countries. But they need to preserve the company that provide the evidence through a leniency deal. So it was difficult how to share the evidence, the information with other prosecutors of other countries so they can use the evidence to build their own cases against the public officials who took the bribe, and even so protecting the company who revealed the facts. So it was a quite difficult situation. Usually the prosecutors established a condition that if you want the evidence, you could only use it to prosecute the public official who took the bribes, but not the company. Sometimes this they get the proper comprehension from their counterparts. Sometimes the prosecutors of the other countries refuse to accept the evidence in this situation. So sometimes you need to build solutions. Mm-hmm. But when you start to work more and more in international cooperation, the trend is that you will build better practice, and also will have further and stronger cooperation in the future.
Yeah. So just like you described, it seems like the willingness to cooperate by the authorities is going even further than what all regulations can do to catch up with that cooperation, right? And but certainly the fact that you made it so clear, there is more and more cooperation in the years ahead coming from different authorities. And Cara, not only authorities cooperate among themselves, but also from time to time they get lucky and they get cooperation from whistleblowers, right? Some kind of scenario that was not that common maybe years ago, but nowadays we are getting more used to seeing not only whistleblowers coming up and disclosing information to the authorities that would make a difference in the chance of prosecuting case, but also whistleblowers getting rewards by the authorities. What has been your experience in this regard, and how this impacts strategic decisions that are made in the context of internal investigations?
Yeah, so I think in the U.S. it was the Dodd-Frank Act that put into place the whistleblower provisions for the SEC that allows the SEC to pay bounties to whistleblowers. This is a very remunerative program. In fact, the SEC just announced last week, I believe, that they have now paid out more than $1 billion to whistleblowers who have provided basically, firsthand or significant information that the agency was unaware of, that have allowed either the SEC or the SEC in conjunction with the Department of Justice or another authority to bring a case. And whistleblowers under this provision can get 10 to 30% of the total amount of the recovery. So in an FCPA case, for example, that can, and in fact for some whistleblowers has resulted in tens of millions or sometimes over $100 million recovery. That is very significant incentive for people to come forward. And one of the things that has truly been a game changer for companies when they're assessing, do we do an internal investigation? And if we do it, do we need to disclose it to the authorities? The whistleblower provisions were a game changer, because you now no longer have the luxury of assuming that if you do an internal investigation and you fix the problem and you complete your remediation and move on, that that's the end of the matter. You have to assume that, particularly if it begins with a whistleblower complaint, if you got a hotline tip that there was a problem, you have to assume that the whistleblower may in the future or may already have gone to both the US authorities and also potentially overseas authorities. But also, even if you didn't get the indication of a problem through a whistleblower tip, doing the internal investigation may in fact lead some people to come into possession of knowledge to say, okay, no, I know there was a problem. I wasn't going to be a whistleblower, but now I'm going to tell you that there's a problem. One thing that I think that the SEC had found when I was there at the SEC was that most whistleblowers are either current or former employees and do try to get the problem fixed internally. So that's one important thing, is one of the reasons for doing a good internal investigation is, to the extent possible, identifying the issue and taking the appropriate action. But as you're trying to figure out, do I need to disclose this to the authorities? The fact that there are whistleblower bounties out there has significantly changed the calculus.
Certainly, and this goes to the point where companies evaluate whether they have things under control, whether disclosing the case to the authorities is their decision, right? That assumes that they have all of the information under control, and many times that's certainly not the case. So we are 3 minutes away from the closing of our panel, so I would appreciate to hear from you any final comments, final thoughts on the topic for the panel, which is handling internal investigations. Any points, suggestions that we have not touched upon that you want to bring as closing comments? Maybe, Cara, if you want to go first, that would be great.
Sure, I'd be happy to. So going back to the very beginning where we talked about what do you do when you're starting out an internal investigation and what are the mistakes that companies make. One of them, I think, is treat anything that could turn into an anti-corruption issue seriously. When you're putting your team together, think about putting together not just attorneys, but also forensic accountants, and whether you need to involve your PR people and whether you need to involve your employment or HR people or your HR attorneys to figure out what you can do, so that you're really, if it looks like you have a significant issue, that you have your team in place early. Because once you start investigating, you may lose control of the place where it goes, particularly if it's a big issue. So I think thinking strategically about all of those issues at the beginning can save a lot of heartache for the company at the end. Thank
you, Cara. Sergio, your final thoughts, if you can keep it to 1 minute, it will be awesome. Thank you.
Just jumping in very quickly to the whistleblower programs. when I was Minister of Justice, we were able to approve a law in Brazil dealing with creating whistleblower programs with strong protection for public officials inside the government or in state-owned companies to avoid any kind of retaliation, and also punishing with dismissal other public officials who tried to retaliate against the whistleblower. We also, this law that was approved also has a provision about rewards to whistleblowers. Unfortunately, the law still needs some regulation on this part about the rewards. But I believe that for Brazil, for Argentina, for countries all around the world, that we need to take a look at these whistleblower programs of the United States. It would be valuable also for us to improve our anti-bribery systems, to have similar programs, of course, with the proper adaptations, for example, in Brazil or in Argentina.
Well, now that you are touching upon developments in Brazil about whistleblowers, I should add that whistleblowers sometimes reach out not to the authorities, but to journalists. And that could create the same, let's say, triggers for investigations than when they reach out to the authorities. Actually, this was the initiation of the largest anti-corruption investigation in Argentina. So on that note, thank you both very much. We truly appreciate having you at the conference, and we look forward to having you again at future editions. That being said, we are coming back in 1 minute for the next panel. Thank you.
Thank you.
Okay, we are back now to talk about COVID-19 and corruption. So this is a present matter, a recent matter that there is a lot to be said about. And it has a particular global impact because all of us throughout the world are going through this pandemic together. So for discussing this topic, we have Delia Ferreira Rubio. She's the chair of Transparency International. And we have Muhammadu Diagni, who is the vice president of integrity for the World Bank. So Delia, Muhammadu, thank you very much for joining us today. And let me start by asking you, Muhammadu, what is the role that you play as vice president of integrity at the World Bank? Which is the role of your office? And how do you interact in actual projects that are financed by the bank? So if a company were to participate in any of these projects that get financing from the World Bank, what would be their interaction with your office?
Well, thank you very much, Gustavo. It's a pleasure to be here again to talk about this ever important topic of anti-corruption. And it is a good segue to your question, because the primary role of the Office of Integrity at the World Bank is to help the institution precisely fight fraud and corruption. And I use this term in a very generic manner. It involves different types of sanctionable practices. But for sake of these conversations, we'll just summarize it in the same umbrella of fraud and corruption. So really our main role is to help the institution fight fraud and corruption in our projects. And we essentially do it through three main pillars. There is a detection pillar, meaning we are the investigative arm of the bank. When there are allegations of fraud and corruption in our project, INT is responsible for investigating them. There is a deterrence pillar, which essentially means that once we substantiate that fraud and corruption has happened, we do pursue sanctions, and the bank has a multi-tiered sanction system, which involves INT, but also other units. So INT can directly engage in settlement negotiations with the individuals and the firms that are involved. Alternatively, also, we can submit our findings to another office, which is called the Office of Suspension and Debarment, and they would evaluate the evidence, and it would be their responsibility at that point to recommend what the appropriate sanction would be. And if the OSD recommended sanctions are contested, then there is another layer, which is the sanctions board. This is an entirely independent body made up of external judges, and they would have the final say. So in a very, very quick nutshell, that's kind of the sanctions process at the bank. And finally, I would say the third pillar, which is equally important, is the prevention pillar, really, which is more of an advisory role to leverage our knowledge from both our investigations and our analytics to help the bank mitigate fraud risk before it actually opens. INT does not have a direct involvement in the lending decision-making process. So when the bank is actually contemplating engaging in lending projects in different countries, that's more at the business level. Our colleagues from operations do handle that. But clearly, we do have a lot of information that might be relevant to that decision-making. So our role is really at that stage more of a role of providing information to support the decision-making of senior management and the board.
So now that we have a clear idea of the role that you play, that your office plays, and before switching to Delia, what kind of situations have you faced over the past year and a few months that the world has gone through this pandemic? I mean, there have been a number of situations that relate to corruption and to lack of integrity happening around the world. Has there been any change, Muhammadu, in the kind of, let's say, situations you were dealing with from your office?
Well, I mean, clearly, emergency operations always require heightened sensitivity to fraud and corruption, right? We've got a number of examples in history. We need to have a high sensitivity to the potential that the response and the resources that are deployed could be misused or, quite frankly, in some cases, completely used for purposes other than what was intended. So as a result, we had to really focus a lot as part of the COVID response, of the bank's COVID response. We had to shift a lot of our focus on the prevention side and really reacting and making sure that the right safeguards were in place, working obviously with our colleagues in operations, rather than just waiting until things go around to investigate. So that meant we had to engage a lot with our colleagues in operations to provide support in their due diligence, particularly when procurement was assisted by the bank. We shared a lot of lessons learned based on our past experience to make sure that they built the right safeguards in the different operations. We worked with them on mitigation strategies and the like. So I think from an INT perspective, really the big impact was shifting a big chunk of our attention from a reactive investigative mode to a more proactive advisory mode. In terms of have we seen different occurrences of fraud and corruption, so far the experience has not borne that out. I would say neither in terms of volume nor in terms of the nature of the reported issues. We're not seeing anything that would be fundamentally different than what we would see in the normal portfolio of the bank, in the normal course of business. Part of it, I would like to hope, is because a lot of attention had been put on upfront risk mitigation, and hopefully that's paying off. But the reality is also, we do know that there is a timing difference or a lagging effect potentially between the timing of disbursement and when potential issues might arise. So I think we just have to remain guarded and continue monitoring the situation. But so far, we haven't seen a significant uptick in either fraud allegations related to COVID-19 or different types of schemes that we have not seen in the past.
Well, that's good news. I mean, Delia, in your experience, I mean, you are an anti-corruption expert. I mean, you have been working with real-life cases for quite a number of years. And while you are at the board of Transparency International, you have access to lots of information on what's on around the world in regard to corruption. So what can you tell us what actually happened around the world in your view, according to the information that you have in terms of corruption potentially triggered by COVID? And I'm not talking here about actual cases of corruption, but about the risks, the situations that make it more difficult to handle because of the urgency triggered by COVID-19 and the health emergency.
Thank you for that question, Gustavo. It's a pleasure to be talking with you and Mohammed. And as Mohammed mentioned, each emergency situation, each crisis situation is a situation where corruption risks increase. We warned governments and international organizations in March 2020 in all regions and prepare a risk map for each country saying, pay attention to this because here you can find the window of opportunity for corruption. And we have been reporting corruption all around the world during 2020, both in the South and the North, developed, underdeveloped. So there is no country free of corruption in relation to COVID. In which areas we have seen corruption repeatedly as a model, let's say, as a patron across the world. Public procurement, number one. Public procurement related to corruption. You know that this emergency puts together an emergency plus a sector where yearly $500 billion are lost to corruption or in corruption schemes around the world. $500 billion in the health sector alone. Now, put up there an emergency situation and you can imagine what we find. We find overprices in all supplies related to the COVID situation. Conflicts of interest. Ministers that stop being ministers and the day after they are providers to the same government in Bolivia and the UK. So it's not Latin America or Africa. We see new providers that appear without due diligence, which means a huge opportunity for corruption, money laundering, and fraud schemes. We find advanced payments without delivery afterwards. That was very repeatedly seen in contracts for the acquisition, the purchase of PPEs, the personal protection equipment, masks. Masks, for instance, were a scandal in Germany. We are talking of very serious and robust democracies. We have seen overspending, buying things that the people in charge say, please don't buy that. I have a wonderful example, wonderful, terrible example in Honduras. The health minister says in a note, please don't buy modular hospitals. The day after that, an order was signed by the officials buying 2 modular hospitals. They never appear in Honduras, so you can imagine. Second sector, the corruption in public subsidies, public aid packages or compensation packages in order to face the situation. We have here lack of accountability, packages and monies that went to those who were not qualified to access those resources or really don't need those resources. We saw clientelism in a huge political use of these resources. Also, we see that this was in a way a perfect storm for corruption, because you have weak accountability, lots of opacity, conflicts of influence and undue influence, and then corruption. And the third issue that we find across the world, from India to Brazil or Peru, is the case of petty corruption. The corruption vis-a-vis one civil servant and a person trying to get a bed in a hospital, access to a ventilator, access to healthcare in general, and in many countries they have to pay for that. And the last sector I would mention is the abuse of public resources for private gain, which was the jumping the line sport in order to access vaccines, for instance, in Spain, Peru, Argentina, and many other countries. 5% of the European population, according to our barometer published 2 weeks ago, 5% of the population paid bribes for access to healthcare. Europe, I'm talking about Europe countries. And 20% of the population recognize that they use their influence to access healthcare for COVID.
Wow, that's a lot. I mean, it's like you went through the full menu of opportunities for corruption, and they have been, again, triggered by the COVID-19 pandemic. So the question, Delia, is how was this possible? I mean, what happened to procedures and controls, I mean, that are in place for this kind of procurement situations? And a second question related to that one is it always going to be this way whenever the world faces, let's say, a global emergency? Are we always going to be seeing these kind of situations, or is there a way out? Is there something that can be done to prevent this from happening again?
Yeah, what happened was that in emergency situations, there is an ask from the population to have urgent measures to face the crisis. So the government lowered the accountability mechanism in order to accelerate responses and have that as a justification for what they are doing. And the people is demanding quick responses. So they are not very much interested in keeping the institutional framework working. Although there are standards for emergency responses, according to rule of law, respect of freedoms, etc., they were not respected by all countries. So there were cases where the countries don't respect rule of law or put in quarantine constitutions or accountability agencies, clearly. That's what happened. And what has happened in the past emergencies. I think there is a way out. We have to guarantee in the future that during emergencies, there are urgency accountability procedures, not the usual ones, but ones that guarantee that the resources are going where they must go and there is no abuse of power. And that we guarantee in the future information. Information has been one of the victims during COVID in all senses. And when information is lacking or opacity is the rule, it is impossible or very difficult to control and stop corruption from happening.
Well, quite certainly, I mean, opacity, which is the opposite of transparency, is almost a necessary condition, right, for corruption to exist and develop. But that being said, and taking on your comments about how the urgency created by COVID-19 impacted all of these situations that you have described, I mean, I imagine, Muhammadu, that these emergency situations also impacted the World Bank, right? I mean, if this were the case, how were you able to balance the necessity for, like Elia said, quick responses with the mandate to keep compliance and anti-corruption, let's say, procedures and provisions in place? I mean, what was the solution that you could implement in real life?
Yeah, I think, first of all, an excellent point that I think Delia made is about the fact that during this emergency, I think what has in many countries contributed to a number of the abuses that she just referred to is that in many cases, safeguard mechanisms that normally would have either prevented or mitigated those risks. Many of those institutions actually were, to some degree, put on hold. A lot of the safeguards were not operating effectively. And I think one of the things to really highlight is, in many cases, it's not COVID that caused those institutions to be disabled. It's actually because many of those institutions inherently were weak. There were countries, in many countries where you've noted the abuses, there have been traditional issues around the quality of oversight, governance mechanisms, and the like. And all COVID has done in many cases is amplified those issues and laid them bare. So I think just going back to the point you are making about some of the steps to mitigate the impact of future pandemics is highlighting the importance of really building strong institutions, because that is the strongest mitigant to ensure that even in a pandemic situation such as COVID, appropriate checks and balances are still operating. If that doesn't exist, the situation will just get worse in an emergency pandemic. Now, going back to the question you are asking, that is the challenge, the traditional challenge of, I think, all development institutions in general. How do you balance the programmatic risk of not acting fast enough or in a decisive manner, which typically means disbursing significant amounts of funding in a very quick manner to mitigate the programmatic risk? But how do you actually balance that versus also the fiduciary risk of the money being misused or being used for purposes that were not what was intended? That's a delicate balancing act. And I think the best way to achieve that, essentially at the World Bank, really what we try to do is make sure that throughout the entire process, we take a whole of institution approach. It's not just about the operations colleagues responding, but it really bringing in the risk management perspective, bringing the perspective in terms of procurement, safeguards, as Delia has indicated, and this is very consistent with our experience in general, not just related to COVID. Procurement tends to be a big area where we tend to see a lot of the integrity issues, and we do have expertise in the institution dealing with procurement in general. So those were part also of the response and really helping the institution think through how we would approach even the emergency procurements. financial management experts, also the integrity vice presidency, as I indicated. So really part of the response for the World Bank was a whole of institution approach, where as we designed the programs and the COVID operations, we were also actively thinking through the mitigation and the safeguards that needed to be in place, because that is the real challenge, responding quickly, responding in a very decisive manner, but also making sure at the same time that we are mitigating the fiduciary safeguards. So I would say that was our approach to the COVID response.
And if I may, we have been talking almost at the very beginning of the pandemic with the authorities of the World Bank and the IMF, because of course, everybody was asking for aid packages. We need money, and the countries need the money in that moment, not after a long process of application. But we were asking the authorities of multilateral or regional development banks to invite civil society to contribute with the monitoring of the funds, because it's the people on the ground that can say, well, supposedly this hospital should have received 2 ventilators and the ventilators are not here, probably because someone hospitalized but very influential VIP has taken the ventilator to other place. That was another example, and it happened in Latin America. So we asked multilaterals to keep an eye and use us as civil society organizations on the ground. We have chapters in 100 plus countries in the world. So we can be there monitoring the real use of these funds.
Well, that's certainly important, right? Because in the end, it's not only about devising procedures and mechanisms, but also about implementing them on the basis of real life information, what is actually happening in each of these countries and how these emergencies are being handled in each particular, let's say, procurement case. But touching upon topic mentioned by Muhammadu, which is strong institutions, and making it clear that strong institutions and democracy are on the opposite side of corruption. Delia, I want to go back to you and ask about what's your view on a topic that I know you have been analyzing and studying, which is how COVID-19 related measures, emergency measures particularly, have impacted individual liberties, institutions, and democracy. What can you tell us about that?
Well, really the harm done to democracy and liberties and freedoms in general has been high. And one of the priorities should be to come back to rule of law, effective rule of law, checks and balances, respect for the civic space. Civic space, talking about freedoms, has been really attacked during this pandemic. Journalists, activists, researchers, or those investigating cases of corruption has been the target of many governments. In terms of democracy, we have found, for instance, that there is a statistically relevant correlation between corrupt countries and those countries that issued the more restrictive and arbitrary measures in order to face the emergency, in terms of restricting liberties, restricting freedom of information or assembly, or really just the simple mobilization of people. So there is a correlation between these two things, as there is a correlation between the most transparent countries with those who had solid, robust institutions that were applied even or were enforced even during the pandemic. In some countries, the measures adopted by the governments has been questioned at the courts. The courts has decided, the courts were not in a hold-on situation or a quarantine situation as in other countries. So Robust institutions are clearly one of the issues. What we have seen is concentration of power in the executive with the excuse that only the executive can act very quickly and with urgency, leaving the parliaments aside, which usually can control this or monitor or check the executive powers. We have seen lots of executive orders or decretos de necesidad y urgencia or exceptional measures used without control, where the executive assume the authority of the parliaments or the Congress. And this is very, very dangerous. So I would invite all chapters to remember, all countries or governments to remember, let's say, that emergency is not a blank check to do whatever. The standards to react to emergencies in terms of human rights and democratic institutions are in our international treaties and conventions. They have to respect that. And I hope in future emergencies, they will remember and the citizen will ask to respect rule of law, proportionality of the measures, as access to information and access to control and accountability during the emergency as in normal times.
You know, I was making a note here about that statement. Emergency is not a blank check. That's a quite strong one and seriously talks about how relevant this topic is, right? Because not everything can be justified in terms of emergency. Not only talking about corruption, but only talking about individual liberties, democracies, institutions, as Delia and Muhammadu have certainly discussed. On that note, and moving a bit towards the side of companies, my question to you is, how relevant is, in your view, and I'm talking to you now as two experts in anti-corruption, okay? Considering that, even going beyond the office that you hold nowadays, how relevant are anti-corruption compliance programs existing at companies in collaborating to fighting corruption? And particularly in moments like this, in which, as you described, Delia, governments tend to go through emergency procedures that put aside a number of checks and controls that are used in normal times. So, Muhammadu, if you want to take the lead here, that would be great.
No, I mean, I think private companies play an important role. And actually, this is something that's been discussed a lot in recent past, because I think the role of the private sector, the role of civil society, the role of facilitators and the like in the past has not been significantly underscored. We generally thought about anti-corruption in terms of legislation, in terms of governmental policy, but I think it has become increasingly obvious that all actors, particularly economic actors, play a crucially important role. I think Delia indicated it earlier on. When you take the areas where we see significant integrity risk, including as part of COVID, it tends to be in areas like, for example, procurement, contractual arrangements, and the like. And generally, you have private sector entities involved in that. So I think it's important for the anti-corruption agenda to come to fruition, that it is not just about government and legislation, but it's also about the conduct of private entities and individuals. And this is something the World Bank actually takes quite seriously. All the private companies that are involved, all the companies that are involved in our projects must abide by our anti-corruption guidelines. And we did not make any exceptions actually during COVID, whether it was small contractors involved in our projects or multinational pharmaceutical companies as part of the vaccine rollout. The World Bank was absolutely insistent on making sure that they adhere to our anti-corruption guidelines and that those apply. So I think that's an important element that we always need to emphasize. As part of our work on an ongoing basis, we pay a lot of attention to making sure that private companies are held accountable. If, for example, there is an instance of fraud or corruption in a bank project, I described the sanctions process But one of the outcomes, or something that comes after the sanctions process, which I really did not talk a lot about, but which is worth highlighting, is the integrity compliance process. We have actually an office at the World Bank, which is housed within INT, that deals with integrity compliance. And our approach is not just a punitive approach. Certainly the sanctions process is meant to hold companies accountable, but we actually go beyond that punitive element. I think there is also a desire for a redemptive value in the sanctions process. What we want to see is when companies come out of a World Bank Group sanction, during the period of debarment, they really reform in a substantive manner their business conduct practices, improve their integrity standards, so that hopefully at the other end of the sanctions process and at the end of the debarment period, it's a much more robust company with much higher integrity standards. This work is done one company at a time, but our hope is that actually the net effect, the cumulative effect, is going to be transformational across sectors, across geographies, and entire industries. So just to reinforce the point I made earlier, private sector plays an absolutely crucial role in the anti-corruption agenda, and this is something we fully integrate in the World Bank's approach to advancing the fight against fraud and corruption.
Thank you, Muhammadu. Delia, your comments on this point.
Of course, this is a tango. Corruption is a tango which needs two to dance. So the public sector and the private sector, and the private sector has a very important role to play. It is very complex to fight against corruption, and we need collective action. Of course, compliance programs are key in that fight against corruption, or fight for integrity, if you want to put it in the positive. But what I would say is that these programs are very important and useful on condition that they are really the core of integrity, a culture of integrity in the corporate sector or the company, and not just paperwork. The trend now, and we are working at the World Economic Forum and the UN Global Compact, is going from compliance to integrity, from legality or legal issues to legitimacy. It has to do with this idea of stakeholder capitalism, of public values of companies, of purpose of the corporate sector. And these programs should show that they are really aligned all across the company's work. For instance, my first question when I met Chief Integrity Officer is, how about the incentive system in your company? Are they in accordance to the principles so nicely written in your ethic rules or in your code of ethics? Or the incentives go in one direction and you are asking in the ethic code another thing from the people working in the company? So this coherence is central if we are going to construct a culture of integrity, which is essential.
Well, certainly, just as you described, compliance and integrity, I mean, on your point, requires a comprehensive view. So it will be of little worth having great policies, but the wrong kind of incentives. So it's all about looking into the details and implementation, not only about declaring how we want things to be. We should take care about ensuring that procedures and mechanisms are there to lead things to actually the outcome we are expecting in terms of integrity and compliance. So we are 3 minutes away from closing our panel, and I thank you both again for joining us today. And on that note, I will ask you for your final comments on lessons learned on how to deal with corruption in the context of an emergency like COVID-19, and what can be done better towards future emergencies. Maybe Muhammadu, if you want to go first.
Yeah, I mean, I think some of the points, as we highlighted, are worth reiterating. One, I do believe that institutional capacity is key in many of the countries. So this is not just during the pandemic, but I think even post-pandemic, as we think about preparedness for, because it's not a matter, everyone agrees, it's not a matter of if, it's a matter of when. We'll have more pandemics, we'll have more emergency situations, and the time to really address some of the issues we're seeing now is in the period that we have where there is additional work that can be done around building strong institutions that are resilient, even in a pandemic situation. Just because it's a pandemic doesn't mean that institutions should melt down, particularly oversight institutions. Likewise, we talked about transparency. It is key. Where you have a lot of issues of fraud and corruption, it tends to be environments where there is very limited transparency. And also that points to an item that's been highlighted, I think, the role of civil society, the role of an independent media. All of those factors play an important role in promoting the kind of transparency that I just talked about. Lastly, I think increasingly also thinking through the fact that just as this pandemic has indicated, these are global issues. So whilst the actions taken at the level of one institution, such as the World Bank or a particular country, are certainly extremely important, really it requires a coordinated approach in terms of international cooperation, in terms of the mechanisms that we have, whether it's around intelligence sharing, whether it's around promotion of best practices, enforcement actions, and the like. And I think these are all actions that we need to work on even before a pandemic hits us again.
Mm-hmm. And I would say that we have to recognize that corruption is at the core of all the failures that we are facing as society and the crisis we are facing. So we need collective action, as Mohamedou say, because we have corruption at the heart of the Beirut blast. We have corruption at the fires in the Bangladeshi factories, textile factories. People died out of corruption. Lots of resources are lost to corruption, houses, factories, resources of the people. So either we are firm in collective action, governments, private sector, public sector, civil society, and we can and shall make anti-corruption a priority in the future, or we will keep on doing the autopsies of our failures and our crises just to discover or acknowledge that there was corruption.
Well, thank you both, Mohamedou, Delia, for such a comprehensive view on anti-corruption from a global standpoint, right? I mean, this goes really beyond specific countries, the kind of patterns that we have discussed, the kind of issues about institutions and liberties. I mean, they apply to all of us. So that being said, again, thank you very much for joining us today. And we are coming back in a minute for our last panel of the day.
Thank you very much.
Thank you.
Bye-bye.
Bienvenidos nuevamente, en este caso al último panel del día, que voy a tener el placer de compartir con distintos socios del estudio para contarles un poco más sobre la interacción que tenemos en la práctica de compliance con otras áreas de la firma. En este caso nos van a acompañar Lorena Schiariti, experta en Derecho Público, Enrique Stile, experto en Derecho Laboral, Juan Pablo Rothschild, experto en Derecho Aduanero, y Diego Fernández, experto en IT, Law y Privacidad. Habiendo dicho eso, Lorena, gracias por estar acá con nosotros. Enrique, Juan Pablo y Diego conectados a través de videollamadas. Pero aprovecho, Lorena, para preguntarte directamente, dada tu especialidad, tu experiencia en contratos con el Estado, ¿cómo impactan los programas de compliance justamente en esas contrataciones públicas? ¿Cuál es la relevancia que los programas de compliance tienen hoy para aquellas empresas que quieren hacer negocios con el Estado?
Bueno, la pregunta, primero, antes que nada, un placer estar acá. Bueno, tiene varias aristas las preguntas. Primero voy a dejar de lado todo lo que es el RITE, porque entiendo que lo hablaron hoy a la mañana ya Luis Villanueva y Karina Kuzik. Pero sí hay que partir de la base de que la contratación administrativa en Argentina tiene muchas facetas. Tenés contratos grandes con gran entidad y en la que, por ejemplo, hay financiamiento de organismos internacionales, entonces hay como un mayor énfasis en todo lo que es compliance. Entonces, ahí los programas de integridad, si son buenos programas de integridad, se alinean con esas contrataciones y con esos términos y condiciones perfectamente. Y en esos casos es como que baja del regulador al administrado el lineamiento en materia de compliance. En otros contratos más chicos, digamos, tenemos que recordar para todos aquellos que no son argentinos que Argentina es un país federal, entonces tener regulaciones a nivel contrataciones, a nivel nacional, provincial y municipal. Incluso dentro de esos niveles tenés sociedades del Estado que tienen sus propios reglamentos de contrataciones. Entonces, ahí mientras nos vamos alejando de los grandes contratos que celebra el Estado Nacional y vamos entrando en lo que es la contratación de las sociedades del Estado, de ciertos organismos públicos, entidades autárquicas que tienen su propio reglamento de contrataciones, bueno, en esos casos es como que el énfasis en compliance es impulsado más por las compañías que por las entidades. Es como que en eso las compañías hoy, lo que nosotros notamos, ¿no? Por lo que es nuestro trabajo en el área de contratos administrativos, es que las compañías son las que están marcando el nivel de seguridades y el nivel de recaudos que tiene que tomarse en los procedimientos de contratación. Así que, digamos, la respuesta no es uniforme, sino que depende de cada caso. Más que nada, digamos, porque bajo la jurisprudencia de nuestra Corte, un contrato que debió celebrarse por licitación y se celebra por contratación directa, en sí no implica un delito, pero sí implica que los reguladores van a empezar a mirar ese contrato si no se cumplió, que van a empezar a observar si los precios que se pagaron son los precios adecuados de mercado. Digamos, esas irregularidades regulatorias conducen después a investigaciones que están más vinculadas a los temas de compliance.
Ciertamente, como nos toca ver en la práctica, digamos, de forma cotidiana, es una buena recomendación prestar atención antes de involucrarse en la contratación por parte de las empresas a cuáles son las normas específicas desde el derecho administrativo que aplican a contrataciones de esa oficina, en ese marco, por ese monto, en ese contexto, ¿verdad? Más que estar luego teniendo que resolver situaciones porque se confió en lo que la oficina en cuestión planteaba.
Sí, porque muchas veces lo que ocurre es que se relajan los mismos funcionarios en la tranquilidad de que a veces no existe una irregularidad, no existe un soborno, no existe una conducta inapropiada. Pero bueno, en esta materia no solo hay que hacerlo, hay que parecerlo y bueno, eso es parte, ¿no? Eso es una parte importante.
Totalmente. Una pregunta más antes de pasar a Enrique. ¿Cómo has visto que justamente en este contexto de compras y contrataciones públicas ha impactado las situaciones de excepción que generó la pandemia y cómo eso también impactó en lo que fueran los procedimientos de compliance que las compañías tenían interpuestos.
Bueno, al principio la verdad es que salieron normas específicas con procedimientos simplificados para determinadas compras en el ámbito de la pandemia y en un contexto económico bastante restringido, en que las operaciones comerciales estaban muy restringidas, las compañías estaban muy interesadas en poder beneficiarse de esos procedimientos más ágiles para contratar con el Estado. Muchas veces hubo un abuso y nosotros tuvimos que resaltar la existencia de un abuso, que esas normas específicas no se podían usar en todos los casos y que, digamos, incluso en los casos que se podían usar, no implicaban una contratación directa en una habitación cerrada en la que no había publicaciones y había solo una conversación telefónica y en base a eso se firmaba un contrato. Entonces, empezó así, allá por marzo del año pasado, todo el tema de contrataciones en la pandemia y por suerte o por desgracia tuvimos en el medio un escándalo que fue bastante conocido en la compra de insumos, de víveres, eran alimentos, que incluso se habían comprado por precios superiores a los precios máximos que había fijado la autoridad administrativa por ese entonces y precios máximos que estuvieron vigentes hasta hace muy poco, y la mediatización de ese caso generó y nos ayudó a nosotros, ¿no? Como consejeros de las compañías que querían participar en esos contratos, a abrir los ojos y a mostrarles un claro ejemplo de lo que pasaba si había un abuso de esas normas específicas.
La verdad que, como nos tocó mencionar en distintas oportunidades a los clientes, si hubo una emergencia, algo de emergencia todavía hay, eso no significa que el resto de las normas, sobre todo las normas anticorrupción, están suspendidas o dejaron de estar aplicables, ¿verdad?
Exactamente lo que dijo Delia hace un ratito, esto no es un cheque en blanco y bueno, como enseñanza que nos quedó y le quedó a muchos de nuestros clientes, algo que implementamos exitosamente fue establecer ciertos procedimientos para la contratación con el Estado, para la autorización de la contratación con el Estado, simples, sencillos, pero que, digamos, le permitía a cada sector de legales de una compañía o a cada responsable de ventas de una compañía hacer un chequeo de los elementos esenciales que tenían que estar verificándose para poder avanzar en esa contratación.
Bueno, muchas gracias, Lore. Ahora pasando a conversar con Enrique sobre algunos aspectos clave de derecho laboral. Enrique, nos ha tocado en numerosas ocasiones ver con vos aspectos de derecho laboral que surgen en las investigaciones internas. ¿Qué nos podés contar al respecto?
Bueno, gracias Gustavo. Hola a todos, espero que estén todos muy bien. Bueno, acá lo importante es enfocar la investigación para no premiar con una investigación a un funcionario que violó políticas de compliance, ¿no? Sobre todo sabiendo que son altos directivos la mayoría, con sueldos y bonos importantes que pueden impactar en sumas muy altas que uno no quiere premiar, sobre todo si incurrió en una violación de las políticas, ¿no? Entonces, acá lo importante es juntar evidencia de modo fehaciente que uno pueda defenderse realmente ante un juez frente a un cuestionamiento, un despido con causa, ¿no? Y si hablamos de despido con causa, el texto tiene que ser claro, no tiene que dar lugar a dudas, y tiene que mencionar hechos concretos, con fechas, acciones. Por eso es muy importante contar, previo al despido, con una investigación, idealmente hecha por un tercero o por un experto, contar con un informe y en base a ese informe tomar la decisión de vincular al funcionario. ¿Cómo hacer para estar bien posicionado frente a cualquier despido que uno va a realizar y de alguna manera rechazar el reclamo? Bueno, primero hay que hacer bien la investigación y contar con hechos fehacientes. Es importante contar con escribanos, que verifiquen toda la prueba, entrevistar testigos frente a escribanos, porque uno sabe que los testigos en 2, 3, 4 años se fueron de la compañía, se olvidan, se amigaron con la persona que echaron, se olvidaron, lo que sea. Y hay un máximo de 5 testigos. Entonces, si uno obtiene gran cantidad de declaraciones juradas firmadas ante escribano, puede contar con mucho más pruebas. Es importante, obviamente, acá hacer auditoría de emails y de WhatsApp, pero para esto previamente hay que contar con políticas, hay que contar con el consentimiento previo por escrito. Esto es ideal tenerlo antes y no en el momento que uno empieza la investigación. Hay que ser muy cuidadoso también acá con el tema de datos personales, que la cosa no salga mal y que el funcionario pueda hacer un reclamo por daño o buen nombre y honor cuando la investigación empezó a verse temas que no tienen nada que ver con el punto en cuestión, ¿no? Y acá lo importante es contar con políticas y hacerlas cumplir, ¿no? Si uno cuenta con políticas claras, las hace cumplir, hay capacitaciones, hay recordatorios, uno va a estar siempre mucho mejor parado frente a una política que nada más existe, que se usa cuando hubo una denuncia ocasionalmente, ahí podría aparecer un hecho discriminatorio. También es importante, en el caso de las empresas internacionales, que las políticas estén en un idioma local. Y bueno, acá lo importante es estar preparado para no premiar a alguien que violó políticas o violó normas. Y bueno, sentirse sólido frente a eso. Como estamos, hemos trabajado en varios. Y otra opción más que se puede hacer cuando el funcionario es el destacado y la gente tiene miedo de colaborar o denunciar, es una suspensión precautoria. La ley lo permite. Se puede suspender al funcionario con goce de sueldo durante un periodo para poder, no sé, entrar en su oficina o hablar con la gente de su equipo, sin que se siente intimidada ni presionada para poder hablar y colaborar.
Sí, hay ciertamente, Enrique, en lo que describís, como un menú de opciones, ¿no? Que caso por caso vamos analizando para decidir, según la estrategia de la situación que enfrenta la empresa, cuál es el mejor paso a tomar. Dentro de lo que mencionabas, una gran pregunta es si se toma la decisión de despedir a un funcionario, si se despide con causa o sin causa. Hay muchísimo para hablar al respecto. Y esto va mucho más allá de que se tengan elementos para probar la causa del despido o no. También el momento, eventualmente, para despedirlo. Si lo despedimos demasiado rápido, es probable que nos quedemos sin la oportunidad de entrevistarlo y terminar de entender bien lo que pasó, que en el marco de la investigación interna es el objetivo primordial. Pero, Enrique, yendo un paso más allá, ¿qué nos podés contar sobre las situaciones de maltrato laboral que cada vez más son parte de los programas de compliance, motivan políticas, motivan entrenamientos, capacitaciones y aún también investigaciones internas?
Buenísimo, sí, bueno. Hoy el tema está en boga. Las empresas cuentan cada vez más con políticas de diversidad e inclusión, ¿no? Donde acá lo importante no es contar con una política, porque tener una política que no se capacita a los empleados, no se hace cumplir, que los funcionarios no la respetan, no sirve. Entonces, si uno cuenta con una política en estos temas, hay que hacerla cumplir, hay que dar el ejemplo, tiene que haber capacitaciones continuas, tiene que haber equipos, permitir que toda la gente participe, no solamente porque probablemente haya minorías que no participan. Entonces, esto no es solamente tema de maltrato laboral, sino en el mundo de hoy es tema de inclusión, ¿no? Hay grupos minoritarios, hay diferencias generacionales, hay diferencias de origen social, y todo esto puede generar hoy en día también un reclamo de discriminación, de maltrato. De maltrato laboral también incluso temas de discriminación, temas de que alguien no pueda acceder a un puesto por su origen social o a un ascenso. Entonces, es importante acá contar con políticas claras. Y sobre todo el maltrato, ¿no? La gente hoy en día es muy sensible, hay que ser muy cuidadoso, hay que dar charlas sobre sesgos inconscientes, que está bien, que está mal, actitudes que antes estaban bien o no están tan bien. Entonces, el empleador de esta manera se va cuidando, porque obviamente un caso de discriminación es un caso grave, nadie quiere que su empresa figure como el caso X por discriminación, por maltrato, entonces es importante cuidar la imagen de la empresa acá. Entonces, los gerentes tienen que saber, los funcionarios, que cualquier hecho de maltrato y discriminación es para un despido con causa. Obviamente, igual que en el caso anterior, hay que armar la prueba, hay que tener un canal de denuncia, realizar la investigación correcta. Y respondiendo a lo que recién preguntaba Gustavo, también acá es el principio de temporalidad. Una vez que uno se entera del hecho, la empresa tiene que realizar la investigación y actuar rápido. No puede despedir a una persona 2 o 3 años después. O sea, hay que actuar rápido con la investigación. Es un principio de temporalidad. Una vez que uno se entera de un hecho, tiene que realizar la investigación y proceder. Y bueno, y en estos casos de maltrato, aquí hay que contar con un canal de denuncias. Lo ideal es que sea administrado por un tercero y no por la compañía, porque sería muy difícil tener que denunciar al CEO, al CFO, o al gerente de recursos humanos, o a la gerenta, porque en este caso la gente probablemente se siente intimidada hacia una denuncia. O sea, acá es muy importante que sea un canal manejado por externos, ¿no? Y hoy en día, sobre todo en la Argentina, hay que ser muy cuidadoso, porque también hay muchas denuncias falsas, ¿no? Alguien que no tuvo un ascenso, alguien que no fue promovido. Incluso hemos visto casos donde los sindicatos han hecho alguna movida contra un gerente que no era muy amigo de los sindicatos. Entonces, hay que ser cuidadoso con todas las denuncias, obviamente recibirlas, pero realizar una investigación interna antes de sancionar a una persona, porque también si no, cada uno también puede tener un reclamo de parte de esa persona por falsa denuncia, ¿no? También, siendo con esto, es importante informarle al denunciante el resultado de la investigación y las medidas que se van a tomar. Que no sirve, puede ser un despido, puede ser una charla, un coaching, alguna medida para separar a esta persona del grupo, siempre tratando de, si el hecho no es muy grave, de preservar el vínculo laboral. Pero sí, es un tema en boga y la verdad que cada vez hay más normativa, cada vez hay más auditoría de parte de los clientes hacia sus proveedores, que se cumplan con todas estas normas de no discriminación, de inclusión, así que las empresas tienen que contar con políticas y sobre todo, como decía Lorena antes, hacerlas cumplir, no solo tener un lindo papel, sino cumplir continuamente y sancionar a quien haya que sancionar. Esto es muy importante, por más que sea el vendedor, el mejor vendedor, el mejor CEO, el ejemplo es donde radica también después la posibilidad de seguir actuando y haciendo cumplir estas políticas.
Muchas gracias, Enrique. Realmente hay mucho para decir desde el derecho laboral por el impacto que tienen los programas de compliance cuando naturalmente los programas de compliance establecen políticas, procedimientos, mecanismos que en última instancia tienen que ver con la relación entre la empresa y sus empleados. Así que el efecto está ahí para el derecho laboral. Pasando ahora al derecho aduanero. Juan Pablo, nos ha tocado participar en muchos casos juntos y mi primera pregunta es, sencillamente, ¿cómo es relevante el derecho aduanero para los programas de compliance de una empresa?
Hola, buenas tardes. Gracias, Gustavo, y gracias al resto de los panelistas. A ver, creo que el derecho aduanero se da una combinación que es altamente peligrosa. Por un lado, tenemos una actividad que está sobreregulada por distintos organismos y además es una actividad en la que participan muchísimos individuos en distintos niveles y en distintos momentos. Sobreregulada porque las operaciones de importación y exportación generalmente requieren la intervención de terceros organismos del Estado. Los más normales y en los que todos pensamos son el INAL, el ANMAT, temas de seguridad eléctrica. Existen registros especiales para documentar algunas operaciones de importación. Secretaría de Comercio Interior, Secretaría de Comercio Exterior, es también de las más conocidas. Últimamente el Banco Central también está bastante atento a lo que son las operaciones de importación y exportación, sobre todo por el régimen de control de ingreso y egreso de divisas. Y el otro factor que se da también es los distintos componentes humanos. Tenemos importadores, exportadores, a veces tenemos otras empresas en el medio de las operaciones comerciales. Hay veces que en la estructura de comercialización aparecen también forwarders, agentes de transporte internacionales, tenemos transporte multimodal, tenemos una cadena de logística cada vez más compleja. Y a todo esto le tenemos que agregar un factor psicológico al que se refirieron Ren y Richard en su parte del panel, que es la presión que se ejerce, la presión generalmente en términos comerciales, que se ejerce sobre los distintos individuos que intervienen en esta cadena de comercialización. Entonces, yo diría, Gustavo, que el derecho aduanero está claramente incidido por todo lo que son las normas de compliance anticorrupción. Es extremadamente importante que la cadena de valor, la cadena logística, esté conformada por operadores confiables, porque hay mucha gente en el medio y todas actúan en representación de la empresa que importa o exporta desde la Argentina. Creo que una de las cosas, quién sabe, más positivas que nos ha dejado esta situación de pandemia es que de alguna manera se ha relativizado la interacción de los distintos actores, sobre todo los despachantes de aduana, con el servicio aduanero. Hoy hay una tendencia general a una mayor digitalización de los trámites, una mayor digitalización de los expedientes y del cargado de toda la documentación complementaria que hacen las operaciones de importación y exportación. Y obviamente, cuanto menos intervención de individuos haya y más parametrizado y sistematizado esté todo, creo que hay un menor margen para algún tipo de conducta que resulte no del todo compatible con las políticas de compliance de las empresas, ¿no?
Ciertamente, como describís, Juan, esta interacción de los despachantes, los forwarders y cada uno de los protagonistas en esta cadena que mencionabas en cuanto a las operaciones de importación y exportación, implica, en definitiva, la interacción de terceros que pueden exponer a las empresas a responsabilidad por corrupción, en caso de que incurrieran en algún caso de corrupción. En ese marco, una de las medidas habituales que las empresas han venido tomando en los últimos años es tratar de formalizar de la manera más precisa posible la relación que tienen, por ejemplo, con sus despachantes de aduana. Nos ha tocado participar en varios de esos contratos que cada día se hacen más complejos. ¿Qué podrías mencionar en cuanto a los elementos principales que esos contratos deberían contener para que se reduzca justamente el riesgo? En definitiva, siempre hablamos de manejos de riesgos, de eventuales situaciones que posteriormente puedan derivar en corrupción o al menos en sospechas por incertidumbre respecto de lo que está pasando.
Sí. A ver, una de las cuestiones que generalmente observamos, y es una matriz de comportamiento, es que las empresas en Argentina no tienen contratos firmados con los despachantes de aduana. El despachante de aduana es una figura que está regulada en el Código Aduanero argentino y básicamente funciona como un auxiliar del servicio aduanero, pero a su vez es contratado por la empresa, que es quien le paga los honorarios. Entonces, generalmente los despachantes de aduana vienen representando a las empresas, pero cuando uno detecta o cuando se detecta por alguna razón que hay un hecho que es pasible de investigación y uno trata de encuadrar las actividades y las funciones que desarrollan los despachantes de aduana en favor de las empresas, uno termina cayendo en la realidad que no hay ningún contrato, no hay ningún marco normativo que regule específicamente cuáles son las funciones, e incluso en muchos casos ni siquiera está claro cuáles son los honorarios que perciben los despachantes de aduana. ¿Qué pueden hacer? ¿Qué no pueden hacer? ¿Por qué se les va a pagar? ¿Si pueden cobrar gastos extras? Las actividades de los despachantes de aduana son muy variables. Incluso en la Argentina tenemos más de 30 aduanas por las que se puede operar, y claramente cada aduana tiene su propia idiosincrasia, su propia logística y su propia forma de operar. Entonces es extremadamente importante que esta relación con el despachante de aduana, que para muchísimas empresas es un proveedor clave o proveedor crítico, esté claramente regulada, donde se establezca cuáles son las tarifas, quiénes son las personas que van a actuar en representación de la empresa, que el despachante de aduana conozca el código de ética y código de conducta de la empresa, que la empresa consulte al despachante de aduana si tiene un código de ética, un código de conducta, que la empresa le haga una suerte de background check al despachante. Incluso hay empresas que tienen como política interna que para estos proveedores críticos deben operar con más de uno, que creo yo que es una práctica bastante sana. porque no solamente permite tener un benchmark de las tarifas, sino también un parámetro de comparación de la celeridad de los trámites y de los gastos en los que incurren los despachantes de aduana.
Muy claro, Juan.
Creo que...
Disculpame que te corto ahí, sé que podemos hablar muchísimo sobre esto, pero estamos ya llegando al final del panel. Y decía, muy claro lo que planteás, varios de estos puntos los hemos visto en la práctica, cómo generan, digamos, diferencias positivas, ¿verdad? Porque lo cierto es que cuando se combinan esos riesgos que vos mencionabas más temprano con reportes de eventual corrupción relacionados a la aduana, si no están estas reglas claras que comentás en la contratación del despachante, determinar si hubo algún tipo de inconductas va a ser muchísimo más costoso y va a requerir muchísimo más tiempo. Así que realmente tener este tipo de contratos con el nivel de detalle que mencionabas y muchos otros que hoy no vamos a tener tiempo para cubrir, es una recomendación verdaderamente esencial. Dicho eso, gracias Juan. Pasando a Diego. Diego, tenemos una vez más oportunidad de hablar de un clásico ya en las chances que tenemos de compartir paneles, que es cómo impacta los derechos de privacidad en las investigaciones internas. ¿Qué nos puedes decir al respecto?
Bueno, buenas tardes a todos y una pena no poder estar ahí con ustedes en el estudio. Un poco lo adelantaba Enrique en lo que venía diciendo sobre la importancia que va tomando protección de datos personales y privacidad en las investigaciones, y me parece que tal vez a diferencia de las áreas de Lorena, de Enrique o de Juan Pablo, que tal vez surgen un poquito más, la relación con las investigaciones tal vez es un poco más fácil de ver para el que no está empapado en el tema. En datos y en privacidad a veces me parece que todavía cuesta un poco más verlo, y tal vez donde más lo vemos nosotros, lo vemos juntos, Gustavo, lo sufrirás conmigo, es en todo el tema de poder revisar comunicaciones, ¿no? Que muchas veces en las investigaciones es todo, porque es revisar los correos electrónicos, es revisar los mensajes de WhatsApp, es revisar incluso comunicaciones telefónicas. Y hay dos principios generales que son los más interesantes ahí, que es el tratamiento de esos datos personales y cómo, en definitiva, se pueden llevar a cabo sin ningún problema. Enrique hablaba del consentimiento. Y la expectativa de privacidad que tiene el empleado. Sobre datos personales, esto da para una charla muy grande, pero a grandes rasgos, el principio general es que para procesar datos personales, que hay en muchas de estas comunicaciones, hace falta el consentimiento del titular del dato, y eso nos hace pensar, como decía Enrique también, una política clara, bien redactada, en idioma español, para que no haya dudas de qué es lo que se está consintiendo. Y expectativa de privacidad que está relacionado, pero es distinto, y es esa expectativa que tiene el empleado de la compañía de que tiene cierta privacidad. Y hay un tema que es bastante debatible, y cada uno tendrá la opinión que tenga, pero el hecho es que la jurisprudencia reconoce que los empleados tienen expectativa de privacidad en el empleo, incluso en un correo electrónico corporativo. Entonces hay que lograr como empresa, idealmente previo a la investigación, poder hacer que los empleados no tengan esa expectativa. ¿Y cómo se logra? Realmente con una política que le diga de forma clara que el correo electrónico que le están dando es una herramienta de trabajo, que no hay expectativa de privacidad. También con, digamos, hay capacitaciones, mensajes recurrentes, hay varias formas de lograrlo. Y una vez que tenemos esto, digamos, que tenemos la posibilidad de procesar los datos personales por un lado y que no hay una expectativa de privacidad, podemos meternos en el mundo de los documentos a revisar, en los correos, en las comunicaciones. Y es importante hacerlo bien porque una comunicación privada tiene una protección que ir por encima de eso sin una base legal suficiente es un delito, ¿no? Y lo hemos discutido varias veces. Y después, una vez que tenemos eso, Gustavo, viene la parte de si lo podemos compartir o no con terceros. Acá en las investigaciones, y ustedes lo conocen mejor que yo, necesitamos compartirlo generalmente a veces con una casa matriz, con un investigador privado, con un proveedor de servicios. Y aparece también otra vez la cesión de esos datos, la posibilidad de compartir esa información, la transferencia a un país fuera de la Argentina, y todo eso lleva a todo un andamiaje de contratos que no son complejos, pero que hace falta que estén fáciles y estén antes, sobre todo, de la investigación. Así que revisar eso creo que es muy importante. Y por último diría algo que no es privativo de lo nuestro, que es que el trabajo claramente es muy interdisciplinario, no solo entre abogados, como vemos acá, de distintas especialidades, sino que aparecen, obviamente, a veces expertos en forensics, aparecen investigadores privados, etcétera, y el trabajo hay que atarlo, digamos, entre todos y tener todas estas reglas en claro antes de empezar.
Sin duda, como bien decís, es muy multidisciplinario y bueno, justamente este panel, el panel que tuvimos más temprano con otros socios del estudio lo muestra y como bien mencionaba Diego, también incluso con otras profesiones. Con respecto a lo que decías de privacidad, solo agregaría un condimento y es que no necesariamente en todos los países del mundo que pueden estar involucrados en una misma investigación, las reglas de privacidad se dan igual que en Argentina. O sea que hay que estar muy atentos para tratar de encontrar el punto en común entre las distintas reglas de privacidad y de esa forma asegurarse de que la investigación interna es un paso hacia adelante y no estamos generando una contingencia no deseada. Diego, te hago la última pregunta de la conferencia. Nos ha tocado también participar en otro tipo de investigaciones que son cada vez más frecuentes y tienen que ver con ciberataques, con hackeos, con filtraciones de datos. ¿Qué podés contar rápidamente en unos 3-4 minutos sobre los aspectos más salientes de ese tipo de casos?
Digamos, lo que puedo compartir es que claramente hay una tendencia a que estos casos crezcan de forma exponencial. Como vos decís, Gustavo, estamos cada día trabajando más juntos en estos casos, compañías que obviamente sufren un ciberataque, como se conoce, un incidente de seguridad en forma general, y que no les permite, en definitiva, no les permite operar, que creo que es el gran problema. Y muchas investigaciones de compliance terminan demostrando algún tipo de incidente, además de lo que se está investigando. Lo que veo es que hay dos vertientes que siguen estando muy fuertes. Una es, obviamente, un ataque exterior contra la compañía, contra sus servidores, a veces dirigido contra una empresa, a veces le pegan a un procesador, a un proveedor de servicios y desde ahí pueden entrar a las compañías. Y después el clásico, que también se ve muy seguido y seguramente muchos de ustedes también lo conozcan, que es el empleado, ¿no? El empleado infiel, que o permite que alguien entre a los sistemas de la compañía o él mismo ingresa a sistemas o información que no tenía que haber ingresado, la comparte con terceros o se la comparte con sí mismo y la tiene ahí guardada. Estos casos son difíciles de investigar, pero bueno, hay que saber que esto en definitiva es un delito en todos los casos, a veces muy difíciles de perseguir. Yo veo un aumento, Gustavo, ahí en los casos, veo que las compañías están estando cada vez más alerta de cómo protegerse de esto, pero todavía la región en general creo que no está preparada en los, digamos, o para ponerlo en otras palabras, las compañías que sufren un ciberataque, que no son tal vez las compañías que tienen los recursos necesarios para poner todo el andamiaje que necesita en seguridad, quizás en ese ataque es cuando empiezan a ver realmente cómo funciona el problema, empiezan a revisar sus políticas, empiezan a ver que sus proveedores o ellos no estaban haciendo un tema de compliance también, ¿no? Un tema de controlar a cómo los proveedores tienen medidas de seguridad adecuadas y demás, lo cual hace bastante dificultoso operar, digamos. Y no es nada más, porque acá creo que hay un tema, muchas veces se habla de incidentes de seguridad y todos piensan en los datos personales, que muchas veces es tal vez uno de los bienes más afectados, y obviamente cuando hay datos personales hay ciertas obligaciones que se pueden disparar, obligaciones de notificación, ya sea por normas generales, como puede ser el Código Civil en Argentina, ¿no? Código Civil y Comercial, la Ley de Protección de Datos, pero también hay, cuando no hay datos involucrados y hay simplemente información, infraestructura, a veces puede ser hasta lo que es operacional para la compañía, mucho peor, compañías que no pueden operar porque no tenían un backup, compañías que le criptaron todos los servidores y tienen toda una cadena de distribución. Nos ha pasado a ver clientes que tenían que entregar millones de pedidos y de repente no sabían qué era de quién, o sea, a dónde tenía que ir cada camión, de quién era la mercadería que estaba cargada. Y vemos que es cada vez un problema, no sé, muy creciente, diría, para ponerlo de alguna palabra. Sí. Y ahí creo que es importante, y lo vemos con vos también en varios casos, tener en claro qué obligaciones de reporte hay, ¿no? A quiénes habría que avisar, con quiénes habría que trabajarlo primero dentro de la compañía, si hay que avisarle a los clientes, hay que revisar contratos muchas veces y ver que ahí asumimos algunas obligaciones con nuestros clientes de avisarle que tuvimos estos incidentes, inclusive en el caso de los reguladores, hay normas sectoriales, Banco Central, compañías que están reguladas por CNB, etc. Y bueno, hay que revisar bastantes regulaciones al momento de sufrir el ciberataque, Y muchas veces lo primero que la compañía va a intentar hacer es restaurar el negocio y después mirar la otra parte, pero creo que una y otra son muy importantes.
Sin duda, bueno, nombraste más de algunos de los puntos que nos toca ver en la práctica, nombraste unos cuantos, pero no tengo duda de que vamos a ver mucho más de este tipo de investigaciones en el futuro no tan lejano. Dicho eso, Lorena, Enrique, Juan Pablo, Diego, gracias por acompañarnos en el último panel y gracias a todos los que han estado en la audiencia durante el día de hoy. Esperamos que hayan encontrado esta conferencia valiosa. Buscamos, como les dije al principio y como les contaba Santiago Carregal, nuestro chairman, compartir con ustedes el tipo de situaciones reales que vivimos en la práctica. Si todo sale bien, nos encontraremos el año que viene en una nueva edición de esta conferencia, así que gracias por habernos acompañado.